Good afternoon. Welcome to the Appellate Division, First Department. As I call the calendar today, please ask for the time that you actually need. And remember that the panel, if we have additional questions past the time you've been allotted, we'll ask them and you'll have an opportunity to answer. We've read your papers and are familiar with your underlying arguments. More than 5.5 hours of argument time has been requested, so we'll have to cut down on that a little bit. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know how much time you are requesting and who you represent. People versus Juan Mateo. Submitted. TRB Acquisitions v. Yadid. Okay, please.
Good afternoon, Your Honor. For respondents, and we'd like 10, but we're happy to take as much as the court gives to be.
Very good. 7 and 2 and 7.
Thank you, Your Honor.
T. Rosie versus Lambert T. Counsel, we'll give you 3 minutes. D. Penguin Brothers v. Spiegelman. Submitted. FDNY Local 2507 v. City of New York.
Good afternoon, Your Honor. On behalf of the appellant cross-respondent city, I would request 5 and 2, Your Honor. Your Honor, I would be on behalf of the respondent and cross-appellant. We can also take 5 and 2.
Okay, you'll start. 5 and 2 and 5 and 2. People be Musa Fofana. Submitted. Travelers Casualty v. Vale, Canada.
Good afternoon, Your Honor. Cox Hartman on behalf of Vale, Canada, 7 and 3, Your Honor.
It appears you have no opponent here today. Please.
Your Honor, on behalf of Travelers Casualty, request 7 and 3.
6 and 2 and 6. People v. John Wilson.
Appellant requests 5 and 2, please.
5 and 2 and 5. Delise versus Davis.
Appellant, 5 and 2. Respondent, Your Honor, 5 minutes.
5 and 2 and 5. Torres v. Kora Realty.
Plaintiff respondent.
Let's go with 5 and 2 and 4 and 4. On Mandron versus Trustees of Columbia, Justice Rosado is recused.
Good afternoon to the appellant, Your Honor, 5 and 2, please.
Respondent, Trustees of Columbia, request 5, and respondent, plaintiff, 5.
Give you 5 and 2 and 3 and 3. People versus Cabrera.
Appellant requests 5 and 2, please. Respondent, 5 minutes, please.
5 and 2 and 5. Richardson v. Garley.
Respondent, 5, please, Your Honor.
5 and 2 and 5. Jacobson Painting is submitted. Canal v. Structure Tone. 5 and 2 and 4. First case up is TRB Acquisitions v. Yadid. Please.
Good afternoon, Your Honor. James Bernard from Hogan Lovells for the plaintiff appellant, TRB Acquisitions. There are 2 different appeals essentially here. One from the summary judgment decision below dismissing the plaintiff's case, and 2 from the summary judgment decision below granting appellant's anti-SLAPP claim. I want to start with the decision or the summary judgment decision dismissing plaintiff's case. The key issue is whether or not Gottwald, as decided by the New York Court of Appeals, overturns, abrogates this court's earlier decision in TRB, what we refer to as TRB1, where the court recognized an extortion exception to what's otherwise referred to. Yes, Your Honor.
Counsel, why are their claim statements subject to the litigation privilege at all, since the person who allegedly made them, Jack, was not a party to the litigation and had no interest in the litigation at the time he allegedly made the statements? So why does the litigation privilege come into play at all?
You're right, Your Honor. I think there's a fair argument that it doesn't come into play at all, either for the reason that you mentioned or candidly for another reason that's sort of lurking in the papers, which is whether or not the absolute litigation privilege only applies in the context of defamation claims. And,
that was my next question.
Okay. And here we have a breach of contract case. The way the
Why don't you deal with the first question first, because it seems like it might run athwart our initial decision in TRB1.
Yes, Your Honor, I can understand that concern. Obviously, that's what the judge below found as well. I think the key difference is that in Gottwald, the court was concerned with what's called the sham litigation exception.
No, but look, no, go back. I think what the JP was asking you is why in this breach of contract case are we even talking about a defamation litigation privilege?
I agree, Your Honor.
Okay.
And
So have you found any case where any court other than TRB1, which you all teed up, not us,
correct.
right? Have you found any case where any court has held that you could overcome your contractual obligation to keep information confidential by asserting a litigation privilege?
I have not, Your Honor. I can see that my adversary is nodding his head.
Yeah,
that
I'd
he
be
has,
curious
so we'll
because
wait
the
and hear-
last case I saw said you couldn't.
Right.
There's a 2021 First Department case, Rappaport, that says you can't do that. Right? So I'm trying to, putting aside TRB1, have you found any cases?
I have not, Your Honor.
Okay.
So you're really just relying on this court's ruling in TRB1?
That's correct.
Okay.
Although, again,
But in TRB1, that was something that your client put forward to the court, right?
that's correct, Your Honor.
Okay.
That's correct. I think that the way...
And what did you base it on when you put forward that this issue?
Well, I think the way it played out in the proceedings below, Your Honor, is that the motion to dismiss that was ultimately granted was decided on the basis of the litigation privilege, and that then became the focus of everybody's concerns.
So then let's start. What statements are you alleging violated the confidentiality agreement? What statements in particular are you talking about?
Your Honor, they're set forth in the affidavit that our client submitted in connection with the summary judgment motion, and there are essentially two. There are an anonymous phone call that's placed to the lawyers at Reebok, where essentially whoever that caller was says, basically, I know that Jack Yadid, the defendant here, if he's allowed to testify in your trial, will say bad things about the circumstances under which the plaintiff acquired the trademarks that were at issue.
How is that violative of the confidentiality agreement?
Well,
How
because
is that broad statement? How could that possibly be a breach of contract?
Because there's two reasons. First of all, the contract contains both.
So non-disparagement. It has a non-disparagement.
Correct, Your Honor.
And specifically with
What was the
regard to
second-
Reebok.
What was the second statement? I'm sorry, Justice Michael, you go ahead.
No, go ahead, I'm sorry.
What was the second statement you were about
The
to
second statement is also in the record. It's actually a similar phone call, but the person who was making the phone call did it under suspicious circumstances because they used a machine that transcribed text messages into voice to disguise the identity of the caller, which I think in and of itself, especially on
That
some...
was sent to Reebok's counsel?
That's correct, Your Honor. And it was
Was there also an offer of proof at the Oregon trial?
Sorry?
Was there an offer of proof made at the Oregon trial concerning what Mr. Jack Yadid would say if called upon to testify?
Yes, there was. What ultimately happened in that trial, Your Honor, is that there was a motion made to reopen discovery on the basis of these phone calls so that Mr. Yadid could be deposed and then ultimately testify. via deposition.
And that
if
was
you will.
denied.
me, Your Honor.
The motion was denied.
That motion was denied, and then ultimately the case settled before trial.
Well, let me ask you, how do you attribute, oh, I'm sorry, I just want to quickly, how do you attribute these anonymous statements to Mr. Yadid?
Your Honor, it's clear from the, if you will, the face of the statement, because the statement is all about what Mr. Yadid would testify to if given an opportunity to testify. Subsequently, on the motion to reopen discovery, there was an affidavit submitted by Reebok's attorneys about what the substance of that testimony would be. That testimony could only exist if Mr. Yadid told it to someone. But, Your Honor, it also goes to an important point about the posture of this case on appeal,
right.
which is we were denied discovery.
Right.
Summary judgment, we put in our affidavit where we set forth what we believe happened. Mr. Yadid did not put in anything into the record denying that, and we're left with the record as it is right now.
And a part of a breach of contract claim was specifically that there be no disparagement with regard to the Reebok case, correct?
That's correct, Your Honor. Paragraph 8 of the confidentiality clause, excuse me, of the contract contains that confidentiality agreement, and it specifically references the TRB litigation. But as the judge was also noting earlier, the non-disparagement clause is even broader, if you will, because it essentially prohibited the defendant from saying anything disparaging of the plaintiffs here. And I would finally just point out, unless the court has other questions.
I have another question.
Yes, Your Honor.
You've referred to the statement as to what witnesses were going to say in the litigation, which I believe was referred to in the documents as a lay witness statement, but I didn't see that attached anywhere to your papers. Why wasn't, I mean, there were various references to it in various documents. Why wasn't a copy of that provided to us?
Well, I have to check the record on that, Your Honor, because I'm not sure that it wasn't provided.
I couldn't find it. I looked really hard, but if you can tell me where it is, I will be
I will
very
check
pleased.
during the time that I'm sitting down and if I can reference it. But more importantly, Judge, even if that particular document is not in the record before the court, what is in the record before the court is our affidavit in opposition to summary judgment, the summary judgment motion, where Mr. Eli Yadid did recite in the affidavit what it was that Mr. Yadid had said he was going to say at the trial.
Wait, how does he have personal knowledge of that?
Excuse me, Your Honor?
How does he even have personal knowledge of that?
Well, these would be things that Mr. Yadid believed happened by or at TRB, executed by his or effectuated by his brother. And he was a partner, if you will, co-equal.
I understand, but you're saying that your client said, here is what he told them, correct?
Correct.
I'm asking you, what is the basis of that statement?
The basis of that statement is that ultimately, when the Reebok attorneys moved to reopen discovery, when this is the document I'm going to look for, they submitted an affidavit in support of that motion saying what they believed
So
Mr.
we're talking
Yadid.
about like double hearsay here. Double
Well,
hearsay. Okay. I'm just trying to figure out the lay of the
Your Honor,
land.
again, we're on the summary judgment record
Right.
where we've had no discovery,
Right.
where we've not been able to take Mr. Yadid's deposition. And at this stage, I think we've more than raised an issue of fact as to whether or not those statements were made. Mr. Yadid ultimately wants to be deposed and to deny having said any of these things, then that's fine. But we've not even been given the opportunity to do that because discovery's been stayed. The point in the record, Your Honor, where the affidavit of Mr. Eli Yadid can be found is at 1712. And
I saw that. I was really asking about the lay witness statement.
Yeah, I think I have to go and check the record while I'm sitting, Your Honor, to see whether or not it wouldn't really be, I guess, the lay witness statement. What it would be is Reebok's attorney's affidavit on the motion to reopen discovery, where that attorney sets forth what he believed Mr. Yadid would testify to.
Other questions?
There are no further questions.
Thank you, counsel. You have time to rebuttal.
Your Honor, Edward Whipper, Benish Friedlander, Copeland, and Aronoff, on behalf of the respondent, Jackie D., thank you again for hearing us on another motion in the case. Your Honors, Justice Schechter's order on summary judgment should be affirmed for a number of reasons. I would like to take on directly both the questions that Justice Gesmer asked and the questions that both Justice Gesmer and Justice Scarpula asked. Let me start with the issue, the easy issue, which is the issue of what's actually hard evidence in the record on the summary judgment motion. That lay witness statement is not there, and it's never been there in the record.
The major question I raised was about whether
Yes,
anything occurred which is subject to the litigation privilege at all.
that's absolutely right. I wanted to answer your easy question first, which is that there's no lay witness statement. And in fact, the predicate for damages in the case, which is this alleged settlement agreement, is not in the record at all either. There's no evidence of what the settlement was, what the terms of the settlement were, what the negotiation of settlement was. There are many.
Is that because discovery was stayed?
No, it's because they have that. And we've been asking them to put that in the record. In fact, Justice Schechter and her clerk said, how much money are we really talking about here? They're suing for $2 million, which is a refund of the buyout, but they won't say what they paid and what was attributed to Jack Yadid. That's not a discovery issue. That's entirely information that's within their own possession and that they have. And in fact, when you read the lawyer for TRB, in the Reebok litigation, she specifically doesn't even say that the settlement was a result of these alleged statements that Jack Yadid made, but she says it made them consider settlement. So we don't have a hard statement saying it caused them to settle, and we don't have the actual settlement agreement to ascertain if there are even any damages in the case.
Counsel, let's return to the questions.
Yeah, so let's do that. Your Honor, in 2004, in the First Department case, Arts for All v. Hancock, this court held that the causes of action arising out of the defendant's letter to a New Jersey judge presiding over a case involving Arts for All, the fourth cause of action for non-disparagement, were properly dismissed because of the absolute witness privilege. So the question is, how does a
Give us
contract...
the site for that one.
Sure, the site, 583rd 106, which is cited in our brief.
Okay.
And let me keep going for the court. In Denise Rich Songs v. Hester, which is a Supreme Court case, citing to Arts for All, the court held, this is another 2004 case, it has long been the law that statements made in the course of judicial proceedings are absolutely privileged, even
But this is not, these statements are not statements made in the course of a judicial, you made no statements in a course of a judicial proceeding.
Your Honor, that's actually...
And prior to the proceeding, you agreed, you gave up your contractual right to say whatever you want, or your First Amendment right. You signed a confidentiality and non-disparagement agreement. And there's nothing, there was no, you weren't, your client wasn't testifying in a trial, wasn't writing to the judge in the trial. Your client was, the allegation was to another attorney in a litigation that your client had nothing to do with, your client disparaged and gave up confidential information. I can't imagine how the litigation of privilege would apply to that.
I appreciate that comment.
And
Your
I
Honor.
think I have a case, Rappaport, from 2021 that says it directly.
Well, Your Honor, there are several cases that disagree with that conclusion.
I don't think that's right. I think every one of those cases has a defamation overlay to it.
No, Your Honor, that's actually, well, I'll make two responses to that question respectfully.
All right.
One is that each of the cases I was about to read to you were specifically cases that held that either what is called the absolute litigation privilege or the absolute witness privilege, which is the absolute litigation privilege as it applies to witnesses, which is this case, specifically apply to both confidentiality breaches, alleged breaches of a confidentiality clause, or alleged breaches of a non-disparagement
But those cases, don't they involve an individual actually involved in litigation? So for example, an actual witness that is called, or a party to a litigation, or an individual that has commenced an action vis-a-vis a complaint?
No, Your Honor, and the reason I say that is because, and the reason that it's so important to remember what the purpose of the privilege is when evaluating whether it applies to a non-disparagement clause, and I would actually go back and cite the case that's in the preliminary statement of their brief, which is Justice Schechter's holding from 2024 in Beast, which holds that a non-disparagement clause does waive all speech, all First Amendment speech, except statements in connection with a judicial proceeding.
Exactly, except and there is not that here.
There is-
That's
but
the
there is that here.
problem.
We
You
have a
can't,
pending-
you can't get rid of, 1 minute, let me finish my statement and then
Not
I'll
our
give
first
you
rodeo, I understand, no
time
problem.
you say yours. You cannot just ignore your contractual obligations by going to another lawyer and saying, if sometime in the future you asked me, I would say this bad things about the company. That would essentially eviscerate every single confidentiality and non-disparagement agreement. Yes.
In Beast, which is cited in their preliminary statement, Your Honor, and I'll go back to the other point that I was about to make with respect to the purpose of the absolute litigation privilege after I bring this up. Justice Schechter says specifically, public policy prevents an agreement from imposing liability for matters covered by the absolute litigation privilege. And that is also a breach of a non-disparagement and confidentiality agreement case.
But that doesn't help us because we're not sure that that privilege applies at all here, because the statements were made by somebody who was not a party to the litigation, had no financial interest in the litigation, and wasn't even being considered as a witness in the litigation. At best, he was volunteering to be a witness.
Well, but that's the point, Your
And
Honor.
the
is that
privilege is supposed to be narrowly defined in any event.
But Your Honor, I have two responses to the same, really the same point that you're both making, which is that the privilege extends by the cases that we cited and Justice Schechter cited and that TRB1 relied upon to all statements, quote, in connection with a pending proceeding.
No matter how remote?
Well, these aren't remote at all. The allegations here are that Jack Yadid wanted to testify against his brother, none of which is true, by the way, but okay, that he wanted to testify against his brother and volunteered testimony in an already pending litigation to a lawyer. That was, how else does somebody come forward as a witness other than to approach a lawyer and say, I want to testify? It would abrogate.
How about the Reebok lawyer saying this guy might have information and trying to subpoena him, which he couldn't do,
Great
right?
point, Judge. And do you know that actually happened here? And it's on page 718 of the record. That did happen. And Eli
He
Yadid.
invited the subpoena, actually, or allegedly.
No, but before that.
And the
he didn't invite-
statements were made before the subpoena was issued,
No,
correct?
Your Honor.
Correct?
But no.
Some statements
No,
were.
wait a second. Just wait a second, because that's not accurate. After this alleged call was made, Mr. Henn, who was the lawyer for TRB, called Aaron Fox and said, may I speak to Jack Yadid? And again, the allegations on the call are just that Mr. Yadid has some information. That's all that was said on the call.
Well, if we had discovery, we'd find out more.
Well, the allegations on the call are contained in an affidavit from Mr. Henn that gave rise to the case. And backing up for a moment, Mr. Henn asked to speak to Jack Yadid well before he was subpoenaed. And do you know what they said to him? They lied. Aaron Fox lied. This is, again, page 718 of the record.
I'm just, may I interrupt you for 1 second?
course.
To say, sure, that's your allegation is you haven't made out any claim of violation of the agreement. You've gone in a completely different direction, which is everything that man said that was within a million yards of this other litigation is privileged.
But that's
a very difficult and a different thing. to say.
But Your Honor, I would respectfully disagree with that characterization because
Okay.
and I'll tell you why. The only allegations of anything Jack said were specifically to a lawyer in the context of giving testimony in a pending litigation. If the court holds that a witness is not free to communicate information freely, true or false, it is going to shut down the process of witnesses coming forward and saying, I want to testify. And do you know who did that? Eli Yadid did that. How did he do that? And please let me finish this one point because I think it's really important, and I know my red light's been on a long time. And this is something that the arbitrators commented on in that arbitration. He said, Mr. Yadid is the president of CPB. He can't testify. His relationship is privileged. This was after Eli threw him out as the president of CPB. They made every effort to stonewall Reebok's access to Jack Yadid until a judge said it was too late to do it. They gave the impression the whole time that Mr. Yadid wasn't available.
So what,
then they specifically
Counsel, but
lied.
what follows from that? You're just saying that anchors it more closely to the Oregon litigation. Is that what you're saying?
I don't think there's any need to anchor it more closely. The statements are pertinent to the Oregon litigation. The only phone calls alleged to have been made were phone calls to the lawyer in the Oregon litigation for the purpose of testifying. And that's what makes it, respectfully, Judge, a statement in connection with a litigation, which is what Judge Schechter has now found 3 times and what this court, in reversing Judge Schechter, found the first time.
So what I would say in response to that is if I 100% agree to you, if somebody subpoenas me to testify in a case, I am not allowed to rely on my non-disparagement agreement and breach of my confidentiality agreement. 100%, because public policy says that you can't do that. That is a different cry from saying I can go to a lawyer who I know is adverse to my adversary and say I have dirt on this person. That, I think, is not, I disagree. I don't think it's covered by the privilege. I just don't.
Your Honor, I respect your view. And you know that this is not our first back and forth
No.
in the courtroom. I respect your view. Unfortunately, my view of that view is that it's contrary to the cases where lawyers volunteer, where witnesses volunteer their testimony, and that testimony and the statements that they make to the lawyers are privileged under the absolute witness or absolute litigation privilege. That's what we're talking about. And Justice Schechter herself, and again, we're not talking about my view, we're talking about a view that's been articulated by both Justice Schechter and frankly, this court. I know that none of the judges.
I was on
that panel.
TRB 1, so yes, I'm familiar with that.
Yeah, right, exactly. I mean, that court held that there was an exception that needed to be created because the statements were within the absolute litigation privilege.
I think that's because of the way you teed up your motions to dismiss. You've made 2 motions to dismiss and a summary judgment motion. You tee them up the way you want them, and we have to respond the way you tee them up.
I respect that, Judge, but I have an adversary, and in his papers on the original motion to dismiss, there were many changes of position from what he's arguing now.
Okay.
But one of the changes in position, Your Honor, was that he argued solely for an exception. And by the way, as we get back to the main point here, which is Gottwald. Gottwald says that.
Counsel, that's a bit of a deviation. Justice Gesmer has one more.
Of course.
Ask a question.
Twice in response to our questions, you referred us to page 718 of the record.
Sure.
Page 718 of the record is a list of authorities. It doesn't help us.
I
I
apologize.
mean, it's an interesting list of authorities, but.
I apologize. Thank you for pointing that out. I appreciate that.
That's why it's on my computer.
It's a letter from Oved and Oved that attaches an email from Arnie Reeder. An email exchange between Arnie Reeder, who's the lawyer for TRB, where he says that the case was referred to. Where he says that he could not speak with Jackie Deed because Jackie Deed was the president of CPB, and then that comment is described in the Oved and Oved letter responding to the panel. I just have to find it. I'm sorry, Judge. I thought it was 7:15, but I could be wrong.
It's all right, counsel. Thank you very much.
Appreciate it. After his argument, I'm happy to find it here and pop up and just give you the page, okay? Thank you. Is that all?
Yes,
I appreciate the time. Thank you.
I'll give you a little extra time, counsel.
Your Honor, to the question of the witness statement, the statement itself is not in the record, but it is quoted in the record in 2 places, so I wanted to give you those sites. I mentioned earlier Mr. Eli Yadid's affidavit in opposition to the motion for summary judgment in the record at page 1712. In paragraph 51 of that affidavit, he recounts what was in the submission that was made to the court in California about what the witness would say, the witness statement that's at issue.
That would be a hearsay statement.
What's that, Your Honor?
A hearsay statement.
Yes.
Triple
yes, Your Honor.
hearsay statement.
We're at a summary judgment stage where we haven't had any
And
discovery.
what's the other location?
I'm sorry?
And what's the other location?
The other location is in the complaint. That paragraph was also cited and quoted in the complaint at paragraph 79. I wanted to address just briefly, because it's sort of circling around here, that even if the court ultimately is concerned about whether or not the litigation privilege can apply to these statements made at different times in different contexts, I think it's important to remember that in the answer here, the defendant denies making any of those statements. So the concept on this record, before there's been any discovery at summary judgment, of saying that defendant is entitled to get the benefit of a privilege, the communications about which or concerning he denies making, strikes me as premature at best, because we don't yet know whether or not the statements were actually made. That's subject to discovery. I'll just point out, it's in the defendant's answer, and it is at pages 3 to 5, and 3 to 4, and 16 to 20. I see that my time is up.
You can continue, counsel. There may be other questions as well. I'll ask you about Gottwald.
Yes, please.
Does that destroy this case?
No, it does not. And what I was trying to get at earlier, Judge, is that Gottwald essentially overturned 2 earlier decisions of this court about the sham litigation
No, I know
exception.
you said that. About Flomenhoft was overturned.
Correct. And I think the key difference between what this court did with the extortion exception and the sham exception is that the sham exception...
Again, I don't even know, what do you mean by extortion? There's no cause of action in New York for extortion. You're entitled to threaten litigation. There's nothing illegal or immoral about it. So tell me, when you're talking about extortion litigants exception, that to me is precisely motive. Here is my motive for making...
No, it's
this
not, Your
statement.
Honor. Let me make it clear why.
I don't know how you could say that, but okay.
I'll back it up.
Okay.
The way that you could say that is because extortion is do this, or I'm going to do that. And here, the do this or I'm going to do that is pay me more money, settle with me for more money, or I'm going to go to Reebok in California and tell them about all of your bad acts.
And what's illegal or immoral about that?
Well, it's false. And
Oh,
the
that's different. That's a different thing. But
That's
you say
extortion,
it's
Judge.
Extortion.
that's extortion.
How about if it's true? Is it extortion then? If I say you either settle this suit with me or I'm going to go and tell my story to the world, why would that be extortion?
Well, counsel, it's breaching the contract, right? Where
It would
you
be
were-
a non-disparagement clause.
That's a different thing, right?
Exactly, but Your Honor, there's 2 different ways to approach this through the agreement, the settlement agreement here. One is through confidentiality, and the other is through non-disparagement. I'd just like to return to the Chief Judge's question about the difference between the JP. Thank you.
It has a ring to it, Chief Justice.
Sorry, Judge. Gave you a promotion. The key really is this question about malice, because what troubled, I think, the Court of Appeals in Gottwald with the sham exception was that it hinged on some kind of showing of malice. There's no malice requirement in connection with extortion. It's this notion of a quid pro quo.
Counsel, does Gottwald overrule Posner? If so,
I'm just pausing to think on that for a second, Judge.
if so, how? Especially if the court didn't mention Posner and it's their case.
It did not mention Posner or Bosner. I'm not
Posner
sure.
sounds
I
good,
don't know
too.
the answer to your question, Judge,
Okay.
to be honest. I know that the New York Court of Appeals in Gottwald obviously did not mention Posner, which was the basis for this court's decision in TRB. And so I believe that it therefore did not overrule TRB1. And more importantly, it cited to its own prior decision, Yeomans, where the court had held that if the litigation privilege is abused, it's no longer applicable. And this court relied on that in TRB1.
Thank you, counsel. Thank you both.
Thank you.
Your Honor, I do have the cite at 758. I apologize.
758.
Email from Mr. Reader saying in response to your question as to whether or not you can call the president of CPB, Jack Yadid. Mr. Yadid had been in arbitration and been removed by that point.
Thank you, counsel. We have the site. Appreciate it. Have a good day. Okay, Rosie T versus Lambert T.
Good afternoon, Your Honors. And may it please the court, I'm Leah Edmonds of the Children's Law Center, appearing on behalf of the child. We're asking the court to affirm the order on appeal dismissing the mother's family offense petition to the extent
Also, maybe put the microphone a little closer.
that the court held that the mother failed to state a cause of action.
Against herself or the child?
We don't have a strong position regarding an order of protection for the mother, but we do oppose the mother's application for an order of protection with respect to the child.
Why?
The course of conduct that's alleged by the mother's own account culminated in the incident in November 2021. And while it's true that the mother alleged that incidents took place in the child's presence, most notably the November 2021 incident, the sole incident that took place subsequent to the expiration of the order of protection that was issued in connection with the neglect proceeding was an instance when the father appeared outside of the mother's apartment building carrying a birthday cake on the child's birthday. So there was certainly...
Allegation in the record about a birthday cake, is there?
I'm sorry?
I'm sorry, I hope that you're referring only to things that are in the record.
Yes, Your
You're
Honor.
referring to the family offense petition, right?
Correct. The mother did allege that there was various incidents while the parents were cohabiting where the father was aggressive or violent towards her, sometimes in the child's presence. ACS commenced a neglect proceeding. A temporary order of protection was issued in connection with that proceeding. So eventually, because the mother filed a family offense petition, she functionally had 2 years order of protection minus 27 days.
Counsel, we know the procedural history. We want to know why you think there should be no possibility of obtaining an order of protection on behalf of the child in the new proceeding. It sounds like you're concerned about the relationship with the father and the child. So
Correct.
tell us about that.
Correct. So prior to the father's departure from the family home, he and the child had a good relationship. Since then, the child has very much wanted to spend time with the father. He was initially somewhat...
And is this in the record?
That is in the record. He had some trepidation immediately following the incident that spurred the neglect proceeding. But as of the culmination of the family offense proceeding, he very much wanted to spend time with the father. Most recently, when I spoke with him in connection with this appeal,
So that's not in the record, right?
my interview with the
Your
child.
recent conversation with him is not in the record,
Correct. Correct.
I
However,
would find it helpful if you would stick to what's in the record.
yes, Your Honor.
So may I ask you a different question? May I ask you, so we all agree that with respect to the child, the November 21 incident was litigated and that can't be litigated again, right? And the only other, so your position is the only other allegation with respect to the child is that the father showed up in front of the home, and you're saying that's insufficient to support a second request for a stay-away order for the father as to the child. Is that my understanding correct?
Correct. And there's nothing in the record to reflect that the child was even aware that the father appeared, but there certainly was a legitimate purpose for his appearance in that it was the child's birthday. And so there's nothing in the record that indicates an ongoing course of conduct by the father directed at the child that would give rise to the need for an order of protection on behalf of the child. And any such order arguably would get in the way of them forming a stronger relationship, which is what the child wishes for.
Counsel, you're talking about actions directed at the child. If we remand it with regard to the mother's petition, and she testifies to events which occurred, which were violent towards her, but in the presence of the child, wouldn't that justify an order of protection that would extend as to the child?
Well, is there any of that in the record before us now? You know, we want to stick to the record, right?
Right, sorry.
To the extent that the mother's family offense petition is in the record, she certainly alleges in general terms that there was a course of conduct up until
But
November
nothing specific
2021.
to sustain the cause of action.
apart from the mother's allegations with respect to the November 2021 incident.
Which you're not taking a position on, but that was, but could be, but isn't subject to res judicata.
Correct.
Okay.
It's not subject to res judicata.
Any further questions? Thank you, counsel.
Thank you.
FDNY Local 2507, the city. I thought FDNY was the initial appellant. That's why I said you would go first.
No, we cross-appealed.
Oh, I'm mistaken. Okay, the city, you go ahead. Ah, right, okay, sorry. I misinterpreted what I wrote. Please.
Good afternoon, Your Honors. May it please the Court, Susan Paulson on behalf of DCAS and FDNY. Your Honors, on the appeal and in response to the cross-appeal, I'd like to talk about the manner in which this case implicates 3 limitations on FOIL's broad disclosure requirements, and I'd like to address the 3 limitations in turn. The first limitation is that FOIL does not require an agency to produce records it does not
Counsel,
possess.
we know the limitations, and you wrote an excellent brief about them. But the CWA case, sort of to a layperson, it looks like, oh, you did it in the CWA case, why don't you just do it here?
Your Honor, there were various litigation decisions that led to the city not appealing that case, and the city complied with Supreme Court's order. In light of repeated similar requests in UPOA in this case, the city has taken a different position, has pursued its appellate remedies.
And there's almost never governmental estoppel. You guys are very opposed to governmental estoppel.
That is correct, Your Honor. You know, that was the first and what, as it turned out to be, a series of cases raising these issues. Your Honor, FOIL does not require an agency to produce records it does not possess or maintain. And Supreme Court properly declined to order FDNY to produce such records and then erred in requiring DCAS to do so.
Well, let's talk about the time testified to that it would take, the time frame that it would take to generate the records. Was this something where computer systems would be able to speak to each other and generate the records within 4 hours, or was there evidence that it would take much longer to generate the records?
Your Honor, that 4-hour testimony was testified by Ms. Bryan about the amount of time it would take DCAS to download the information from its system, one of the 3 databases, the SEEDS database only, to download that information. It did not address the amount of time that it would take FISA to download the other categories of information from the NICAPS and PMS databases, nor did it address the amount of time that it would take to transform and extrapolate that data to produce the records that was requested. And ultimately, the reason why the order with respect to DCAS was in error was twofold. One is that DCAS did not maintain or possess all of the records requested. It is undisputed that
Some of the records were with FISA.
Correct. Yeah. Some of the data is with a separate city agency. But the second reason, and this goes to your question, Your Honor, is because it would disclosure would require more than reasonable efforts, because the information does not just need to be downloaded, even if, for the sake of argument, but there's no information in the record as how long it would take FISA, but even if it would only take FISA the same amount of time, that's not all the time that's required.
You didn't make a burdensomeness assertion under that section of the public officers law. That was not one of the reasons that you
No,
gave.
it's not a burdensome. It's that it requires more than reasonable efforts to extrapolate and transform the data. Okay. The queries have to be developed, the proxy data has to be created to fill the gaps, terms have to be defined for data mapping, computer code to transform it.
So essentially, are you saying you have to create a new document?
Yes, Your
Okay,
Honor,
that's
absolutely.
what you're relying on, that this isn't something you can just press 3 buttons and zip it out.
That is correct, Your Honor.
And is there any dispute about that in the record below?
There was no other witness that testified to the process
What about Chief
involved.
Suchekis? I'm mispronouncing his name. Chief Suchekis, the fellow from the FDNY. Now, is that even before us, what he said? And if it is before us, didn't he have a better understanding of the data than Ms. Doles?
Your Honor, I would absolutely agree. I mean, that information was introduced in this litigation on a motion to renew that was denied. It wasn't part of the testimony that was introduced in the hearings as to these FOIL requests. And as Your Honor points out, he indicated that he was not a data person. But even if that information could be considered, it doesn't establish what my adversary claims that it does. All that he said was in that human resource database, which is separate from the disciplinary action database. The disciplinary dispositions were also in that database. But that's a narrow bit of the information that they were requesting. They were requesting numerous different aspects of the disciplinary proceedings, and then addition, the race and gender. So although the human resource database had the disciplinary disposition and the race and gender, that would not have satisfied the FOIL request. In order to satisfy the FOIL request, you needed the information from the human resource database and the information from the disciplinary database to compile all of the information that was requested. And Supreme Court properly concluded there that pursuant to this court's decision in UPOA, that was beyond the reasonable efforts. It would require the transformation and extrapolation. And the court erred in not finding the same way for the DCAS information. I would say that also this court's precedents.
The red light is on, counsel. Let me see if anyone has any questions, further questions. You have time on rebuttal, of course.
Thank you very much, Your
Thank you.
Honor.
Good afternoon, Your Honors, and may it please the court. Erica Healy-Kagan on behalf of the petitioners below and the cross appellant here. And just to remind us, the petitioners here are two labor unions, Local 2507 and 3621, who are looking to collect information to investigate concerns about pay disparities and disparities.
Your purpose isn't important. Yeah.
Right, the purpose is not
You don't,
for us.
FOIL is, you don't have to
statute.
have a purpose. You don't even have to justify what you're looking for.
Absolutely, Your
The
Honor.
question is whether, in fact, the request is requiring the agency to create another document and whether it is unreasonably burdensome.
Absolutely, Your Honor. And in the court below, respondents did make the argument that if a certain agency doesn't have the exact information that's being requested, that a FOIL request can be summarily denied. And that is what led Justice Hagler to describe the way in which the city maintains this data as a quote-unquote shell game. He was very frustrated in the sense that they relied on the fact that if you ask the wrong agency, your request can be denied. If some of the records may be with one...
But if the agency doesn't have the records, why wouldn't they deny your request if they don't actually possess the records?
Yeah, and that speaks, Your Honor, to the fact that the City of New York actually maintains what's called a dynamic database. All of the databases of the City of New York can speak to each other if the right person is
Can they
asked to
speak
pull.
to each other and then generate a document with all of the requested information?
Yes, Your Honor.
How long would that take based on the evidence at the hearing?
The evidence at the hearing was the 4 hours that Ms. Bryan testified
What
to.
about
but-
the other hours that it would take for the other information to be gathered?
Yeah, Your Honor, in the evidentiary hearing that Justice Hagler conducted, that was numerous days, numerous witnesses, what he himself asked Ms. Bryan, what other than the 4 hours of data, pulling, what else is there? And it was meeting with attorneys and writing up reports and, cleaning databases and whatnot, but it was not the actual pulling of the data. It was doing
But
something
all
else
of those
with it.
other things bear upon the information that needs to be provided. It's not like you can divest just the pulling of the information from making sure that you have all the correct information and that you also, clean and verify the information in order to honor the request.
Yeah, absolutely, Your Honor. But I think when we're looking at data tree and the amount of time that is required and whether it's reasonable to pull the records, obviously nowadays it's not just a document, you walk into somebody's office, you pick up a document, you produce it to the other side. There
What
are
about the confidential nature of the information that's being requested here?
the concern about privacy, Your Honor. Yeah, no, the city, again, has brought up this concern about privacy. However, there's a number of points for which we would oppose that. One, they argue that there is, an absolute harm that will be, that will accrue to these plaintiffs, these employees if their information is divulged, but there has to be an actual harm. It can't just be speculative. The case law says that just because you think there might be some harm in the future, that's not sufficient.
But the information concerning was self-reported race and
Correct.
gender information. So, and I thought there was something in the record showing that was offered or the employees were induced to provide that information because it would be kept confidential.
No, well, Your Honor, the EEO self-reporting form, the promise was that it will be kept confidential except to comply with the law, and it specifically says this information will be provided to comply with the law, could be provided to third parties, and again, we would argue that this is exactly one of those
But
instances.
anonymized information concerning racial and gender information about the employees, or information tethered to a particular name?
Well, in this case, there's no chance that a name is being produced. The order specifically redacts the names. And
Right,
so,
but counsel, wasn't there testimony that at least 25% of the people would be able to be identified because of things like gender, race, and that was not seriously disputed, correct?
no, it was seriously disputed in the sense that the respondent's expert witness only produced a very curated sample and matched, data from database A that was perfectly matched with database B. And Judge Hagler actually said that that expert witness's testimony was not credible, and he did not, he did not credit Dr. Levin's testimony. He only credited petitioner's expert's testimony that said that was not possible, and that it's not likely, and that, again, it's highly speculative to say that would ever happen, and therefore the request should not be denied.
We have another
I have one
question,
more
Counsel.
My recollection, and correct me if I'm wrong, is that the form that employees signed as a condition of revealing their race and so on didn't just say, I understand it can be released in conformance with the law, but actually enumerated specific laws. Isn't that right?
No. I can get you the record site if you'd like, but
find it.
it says, in compliance with the law, we will use this information and potentially divulge it to third parties.
Okay.
Yeah.
Thanks very much.
Counsel, before you sit down, I just have a question sort of about the choreography here. There were like 7 decisions on the record by Justice Hagler, is that correct? Roughly?
There were decisions on the record that then all got compiled into a written order.
And what was the lag time between those decisions that were done on the record, which I think the last one was in 2020, and then the order appealed from is 2023 or something? Can you just explain to us? I mean, maybe it's not important, but what was the lag time?
No, it is important, Your Honor, and COVID was part of it, obviously, but there were, the evidentiary hearing took place over a number of different days, and at the end of certain aspects of it, the judge did make certain rulings, and then after the evidentiary hearing, there were post-hearing submissions, and then there was a motion to re-argue, and again, there was lag time related to some of those processes, and the court also broke down the different FOIL requests, because there are obviously a few that are in play here. He dealt with one at a time, and that really is what led to the lag time.
So, and just as a follow-up, how many FOIL requests were there that were dealt with in this, this sort of omnibus decision?
Sure. There were 4 total, but we addressed them here as kind of 2 buckets. One of them was resolved between the parties. 2 of them deal with the quote-unquote DCAS data, that is the main appeals substance. And then the 3rd bucket, but the 4th request, is the BITS data, the disciplinary records.
So the only one FOIL request to DCAS is on appeal?
There were 2 of them together, but they're being dealt with because they requested the same type of information from DCAS, just related to different employees.
So there are 2 FOIL requests on appeal?
2 on appeal that were addressed to
Just to
DCAS,
DCAS.
and 1 on appeal that was addressed to the FDNY regarding the disciplinary records.
Okay, and so there are 3 requests, obviously, because this is all meshed together.
Yeah.
So the one with respect to the FDNY is not before us. Is that resolved?
No, the one regarding, there were
Yes.
2 to the FDNY, one regarding EEO records.
Right.
The EEO records was resolved.
And then there's one that's still open to the FDNY and 2 to DCAS.
Correct.
Okay.
Right, that's actually a good point. I'll give you 2 minutes on rebuttal because there was a cross appeal as well. I didn't do that at, when I called the calendar, so you'll have 2 more minutes after this.
Thank you, Your Honor.
Counsel, do you need to pick up your notes? You go ahead.
I think I'm okay. But pardon me when I climb under there later. First, I just want to address this comment by Justice Hagler and counsel's argument about this being a shell game. This court recognized in New York Environmental Law and Justice Project and in the 2023 Matter of Jewish Press argument that it's not the city at large.
You don't reify the city as a single agency. We know that.
Thank you, Your Honor. So it's not a shell game here. They're kept by separate agencies, and one agency is not responsible for producing the records of another agency. If I can
So our review has to be based upon some error of law. What would you assert is the error of law by the trial court?
Yes, I understand that we have a high burden here, and I would say that there's no fair interpretation of the evidence that DCAS possesses or maintains the data requested. It is undisputed that some of this data is possessed and maintained by a separate agency. And beyond that, I would say that there is no fair interpretation of the evidence that supports a conclusion that DCAS can, with a simple manipulation of the computer, produce this information. Ms. Bryan's testimony was unrefuted.
So let me just interrupt you for a second.
Yes.
So what you're essentially saying is you have to create a new it's undisputed that you have to create a new document.
Absolutely, Your Honor.
What about the confidentiality argument and this argument that your adversary made that employees were told that their information could be provided in order to comply with the law?
Sure. It does say that their information can be provided consistent with law, and the information is reported to EEO and reported in aggregate form, not in an identifiable. And we would say that it is not compliant with law to provide it pursuant to a FOIL request that makes it identifiable and is unwarranted invasion of personal privacy. So, such that other laws allow it to be reported in an aggregate way, that information that they self-report can be reported. And I would just note in closing here that it's our position that no fair interpretation of the evidence supports Supreme Court's finding that DCAS possesses and maintains this information and through a simple manipulation can produce it. And if DCAS is not required to produce it, this court does not need to consider the personal privacy issue. If this court were to disagree with us, which I would urge it not to, on that point, only then should this court consider whether or not, in upholding that order, this court should order the information about race and gender to be redacted from it. Thank you very much, Your Honors.
Thank you, Counsel.
Just a few points, Your Honor, in response. First, in terms of the cross appeal and whether or not all of the data requested from the disciplinary files as well as the race and gender exists in one place or is maintained by one agency, there is testimony of Ms. Diol that says that HRIS, the Human Resources Information System, has everything, has the disciplinary records and the race and the gender. So even if we are saying that there can't be data sharing between databases or data sets, there is testimony that says all of that exists. Also, Justice Hagler, again, after spending a great deal of time hearing from numerous witnesses and hearing a significant amount of testimony, said that the burden that the city was placing on these FOIL requesting parties was an insurmountable burden and was not appropriate. He said that based on the testimony that was given and what was credible, that getting this information would not be any more difficult, quote, than obtaining a file from someone's office. Again, obviously FOIL laws were created quite some time ago when it was more paper records, and we are coming into, you know, a new generation of data management and data production, and we really just, we can't ignore the fact that many companies, especially the city of New York, as we see it as a company, maintains a great deal of data nowadays, and needs to be able to access that data, especially if it has the burden that the city has and that municipalities have to produce that data to the public. So,
but the question is not whether it should produce it, maintain its data in a more comprehensible way, but whether, given what it is now and given FOIA, whether they've met their burden. I mean, maybe there's a policy argument that they should be maintained in a different way, but that's not for us to decide.
Absolutely, Your Honor, right. And I think that the slippery slope here and what Justice Hagler, made a record of being very frustrated by, let's say, is the fact that if a municipality can avoid its FOIL productions by not maintaining its records properly, that's a problem. And that
The question
is,
what's properly. I mean, if it's proper for their purposes but not for yours, that may be good enough.
understood, Your Honor, but again, after many days of testimony, Justice Hagler was convinced, I would say beyond a shadow of a doubt, that this data can be accessed without very much effort, and that it was a reasonable amount of effort, given the circumstances, what was described to him.
Thank you, counsel. Thank you both. Travelers versus Vale Canada Limited. Please.
May it please the court, Alex Hardiman for Appellant Vale Canada. The question presented to the court today is the statement made by Travelers in its brief.
You mean Mr. Harris's testimony?
I think it's the statement, it goes to Mr. Harris's testimony, but which plays into the statement made by Travelers in its brief, which is a claim for declaratory relief in the insurance context becomes justiciable once the policyholder seeks coverage for an existing liability. That is the standard that both the Supreme Court and Travelers is asking.
So how come you shouldn't be held to your statement to the Ontario court that this is a justiciable controversy?
Because the
Why are you saying to your home court, yes, deal with it, and to us, no, it's not justiciable? How is that?
Because we only found out 3 years after this complaint was brought that in fact Travelers does not deny coverage for this action. To this day, they have not denied coverage. And Mr. Harris...
Well, we've held many times that you don't have to have a form. There's no doubt that they don't want to pay this claim, right? You're not claiming that there's any doubt that they do not believe that they are required to pay the claim.
We don't know that. Their corporate...
Why would you enter into settlement and negotiations with a time period if they were going to pay the claim?
Well, we entered into settlement negotiations in good faith, subject to a settlement confidentiality agreement, which barred the use of that information in any
Honestly, I think, but that
litigation.
is sort of very facetious to say we don't know. You went to the Toronto court of the Ontario
Ontario
court,
court.
right, and said they're not going to pay the claim, make them pay.
And
So the idea that you don't have any understanding where they stand on this is just really, I find, very unfortunate that you're making that statement.
so the reason we went to the Ontario court was based on the bringing of this complaint here, where they said, where Travelers makes the allegation that they disputed and denied coverage. So they file that complaint 15 hours after we give notice
And
of the
made
claim,
a statement that it is a justiciable issue.
and made
And
a
why are you not stuck? Why are you not bound by your statement in a court?
It's not. They made the claim that it was justiciable issue here first, and made the claim that they had denied
Why
coverage.
does that even matter? You made that statement to a court that in your home court, right? Not this court, in your home court. Yes, this is justiciable. Why is it justiciable there and not justiciable here?
Because it was based on the filing of this complaint by Travelers
Oh,
in
counsel,
New
then,
York
if-
repudiating coverage.
If we agree with you then that this case is not distinguishable, you dismissing the Ontario case?
We don't know what will, to be honest, we don't know what
You don't
will
know? Wouldn't that be like an absolute slam dunk yes?
We don't, I am not a Canadian lawyer. It may well be.
All right, counsel, let me ask you a slightly different question. Now, it seems to me really this is based on a new theory, not new facts. So it's not a motion to renew. Tell me I'm wrong, or convince me I'm wrong.
does Travelers deny that there's coverage for Vale Canada's claims that are the subject of Travelers' complaint? That was the question posed to their corporate designee at the deposition. We do not, says Travelers. That is the first time we found that out. It is a new fact.
They say that you relied on, quote, cherry-picked sound bites, close quote. Do you disagree with that?
Yes, completely disagree. It goes on. So we asked for the factual basis at the deposition for the allegations in the complaint. Objection by counsel. I'm going to object and instruct Mr. Harris not to answer to the extent that any information he would reveal would give the context of communications between Mr. Harris and counsel. Goes on, I again would ask that you not try to provide, and to the extent that information that Mr. Harris you would give would be in the context of confidential settlement negotiations, I again would ask that you not provide those so that we eliminate the risk of Mr. Hardeman. We'll try to use that as some kind of allegation that Travelers breached the standstill provision. If you have any other facts that you can provide him outside of what you learned through counsel and what Travelers learned through the standstill period, then you can disclose those. And Travelers' corporate designee answered, those are my two current sources of information. So that's, I guess I'm a little boxed.
Okay, what about record 784, where Mr. Harris, the same Mr. Harris, said, quote, Travelers has not been able to find any basis to determine that there was an occurrence that might give rise to coverage, close quote.
That was general deposition testimony. He was, it wasn't the basis for a denial. It was just saying that they had no information, because the reason they had no information was because they couldn't use any of the information from the settlement negotiations. What I think the court is getting at here is that, oh, this is form over substance, right? Everyone knows what's going on here. Travelers is clearly disputing coverage. Vale Canada clearly is asserting its rights to coverage.
Let me just ask you this for a second. Isn't it a clue that they brought this declaratory judgment action that they are disputing coverage?
No, it's not, because it turns out they brought it based on a false allegation.
Oh, but I mean, you
corporate
might
designee-
disagree, but isn't that your clue that they are disputing coverage?
We thought it was, and that's why we brought the competing Ontario action. They say in their complaint, Travelers disputes that Vale Canada is entitled to recover under the policies, and there is no coverage for the claims. Mr. Harris, their corporate designee, when asked, do you deny coverage for the claims, says we do not, right? So time has elapsed here, but it's an important principle as to justiciability, right? If you allow...
You still haven't answered why it's justiciable in Canada and not justiciable here.
Because
I think you've been asked that at least 3 times.
Yes, because we brought that on the basis of the allegations made in this
If it's justiciable now, then in Canada, then it's justiciable now in New York.
We are asking this court to find it's not just that the two are not the same. We brought it, they repudiated their obligations via their complaint. That turned out to be inaccurate and false. I mean, there's no two ways about it. And so now we're left in the position of saying, hang on, we don't have any investigatory evidence. They've refused to give any testimony regarding the basis for their allegations of no coverage. How is it possible that we're faced with a complaint where we get their 30B6?
Wait 1 second.
Yes.
Does your insurance policy say there is a pollution exclusion for exactly this type of thing? It doesn't take, I mean, this is a pretty run-of-the-mill. There is a pollution exclusion. Their whole point is that the contract itself, they don't need you to say this, that, or the other thing. They're alleging that their contract, their pollution exclusion, excludes your environmental damage claim. There's nothing weird or complicated about that. We're here in New York with those kind of claims. I'm sure you do also in Canada all the time. So your statement here that we have no idea why they would disclaim coverage, really?
It is not. If it was as simple as pollution, if it was as simple as pollution exclusion applies, then why didn't their 30B6 witness say that? They didn't. And the reason he didn't say that was because it's not as simple as that. There's a
Counsel,
sudden...
you have time on rebuttal, unless there are other questions? Okay, thank you. Thank you.
Your Honor, it may please the court. Kathleen Monis on behalf of Travelers Casualty and Surety Company. I think the court has hit this issue square head on.
Let me just ask you, in your complaint, do you allege that the pollution exclusion excludes coverage for this?
We do, Your Honor, and that was the thrust of the disagreement between the parties during the tolling period.
Is there any doubt about that?
There is no doubt, and in fact, Justice Brock issued a decision just last week that we provided to the court on Travelers' motion for summary judgment on the basis that the pollution exclusion applied to bar coverage for these claims. We submitted that decision to the court.
And what do you
That's
say
exactly
about
what's at issue.
Counsel's argument that your lead witness denied that the pollution exclusion applied?
He didn't, Your Honor. I find, I spent the weekend preparing for the argument, and I find it remarkable, some of the allegations. The idea that the complaint in Ontario was only brought because of this complaint. There's no factual record. The reality is they were preparing a complaint, but they didn't
Everyone wanted to get to the courthouse first. Everyone
Honor,
wants to be in their home
that was
court.
that's exactly
legit.
That's what we argued just a few years ago when we were before this court on the motion to dismiss for forum nonconvenience. This is a repackaged attempt, I call it a Hail Mary pass, to get this court to revisit the decision that was made 3 years ago. Mr. Harris testified squarely, and Justice Brock saw right through the cherry picking about what the disagreement between the parties were. There was no breach of a settlement agreement. He relied on information that was developed by Travelers in investigating this very real claim. And to suggest that there is no case or controversy in light of what has transpired in the last 3 years and the Vale's aggressive attempt to move to a trial this year in Ontario, it feigns credulity. I don't know how a position could be taken in a pleading that there is no case or
November
controversy.
2025 trial date?
There, at this point, there is still a 2025 trial date, November of 2025. Yes, Your Honor, in Ontario. So I'm happy to answer any questions. I think this panel has really kind of honed in on what the real disagreement is. I thought Justice Brock did a wonderful job in the decision. Certainly we won, so I would say that. But in all truth, he walked through, and I have a hard time imagining that this court could find an abuse of discretion, given Justice Brock's close read of the deposition testimony of Mr. Harris, the very close read of the provisions of the confidentiality and tolling agreement, and his ultimate conclusion that there is no basis for a motion to renew, and there is certainly no basis on which to base a ruling that the court lacks subject matter jurisdiction on the feigned notion that there is no case or controversy between the parties.
Thank you, counsel.
Thank you, Your Honors.
This matter started with settlement negotiations. And the reality here is that Travelers used the settlement negotiation information and brought a complaint because they wanted to get to their choice of forum. The problem with that is you're not allowed to do that. And when you do that, you have to, when you have your corporate representative testify on your behalf, you have to give a factual basis for your allegations that is admissible. Their corporate opponent, Mr. Harris, admitted that there was no source of information to base its allegations in the complaint on, which is required for an actual justiciable controversy, that they actually dispute coverage in an admissible form for them to bring their complaint. We were startled to find that out 3 years later and brought the motion within 9 days, I think it was, of the deposition testimony. I took the deposition. I was very surprised because if, in fact, it was their position that the pollution exclusion applied, well, why didn't they say it? The reason they didn't say it was because the entirety of that complaint was based on confidential settlement negotiations. And that is not permissible.
They accuse you of talking a lot more about the confidential settlement negotiations in Ontario than they do in this complaint.
That's not accurate. I mean, they've pointed to nothing in the complaint in Ontario that that implicates the confidential settlement negotiations, because it's a lot easier for us, right? We have all the documents.
So in Ontario, your whole allegation as to justiciability is that they said it was justiciable in New York, and therefore that's what we're relying on?
No, it's that they
What else did you say in Ontario to support justiciability?
they denied coverage, and that was based on their allegation that they deny coverage for this claim in New York. And we assumed that, in fact, they had denied coverage. Turns out they had not.
Thank you, counsel. Thank you both. People versus John Wilson.
I know, it's like killing me.
Please.
Good afternoon. Sam Claflin of the Legal Aid Society for John Wilson. This court should adjudicate John a youthful offender for the single drug transaction he committed when he was 17. This case just preceded the Raise the Age Act, where John prosecuted mere months later, he would have been an adolescent offender in family court by operation of law, unless the prosecution...
We're talking about two cases, right? He received youthful offender adjudication on his first indictment, right?
That's correct, Judge. He did,
And while he was doing an alternative to incarceration type disposition and in placement for, treatment and help, he committed another offense.
That's right, Judge. And so I think the context...
And based upon that, the court declined to extend another youthful offender adjudication to him, correct?
That's right. But the court shouldn't have done that. The court should have granted him youthful offender status as to the drug sale as well. The court misread the indictment.
But the standard is whether it was within the court's discretion. Why isn't it?
So this court can substitute its discretion for the sentencing court is one answer, Judge. This court under Anthony C.
Well,
the Court
why
of Appeals
would we?
case-
Why
Yes.
would we do that?
Right. So actually, I think first let's go back to an abuse of discretion, because what the sentencing court said in denying YO here was that John had committed 6 sales. And the court said, quote, if this were a 1 or 2 shot deal with selling drugs, I would be much more inclined to follow through with YO status.
Well, what the court did was cite from the indictment and said that there were a series of sales alleged between, I believe, March 8th and April 18th.
Yes.
Why is that incorrect?
This is critically important. John is the named defendant on only one of those sales. The prosecution misreads this on appeal. The court below misread it. I have the indictment right here. If your honors will review the charges in the indictment, the co-defendant, who was twice my client's age and his girlfriend at the time, is the named defendant on 6 sales.
All right, so there was one sale, right?
Correct.
At the very least, one sale.
Yes.
And the other sales was he not charged acting in concert with his girlfriend?
No, Judge, no.
Okay.
He was not. And I would love it if the court would please revisit the indictment here, because this is something that everyone got wrong. The court below got it wrong. The prosecution gets it wrong here. John is charged in only 1 of the sales and 2 conspiracy counts that appear to have been related to that one sale. Regardless, he was not convicted of those counts. And the conspiracy counts, the dates are the same date of the sale for which he was convicted and 1 day before.
So that's your argument that the fact was that he was only re-indicted for 1 crime rather than more than 1 crime?
The court said...
He didn't go for his pre-sentence report, right?
He did not appear for his PSR interview.
So that was a requirement of his first YO status, correct?
I believe the requirement was that
And he
attend all
wasn't,
court dates.
yes, and so, well, obviously in this, he committed a new felony, correct?
That's right.
And he didn't do his treatment program, right? So
had
the
finished-
3 main things that he was required to do under that first sentence, he didn't do.
He had finished nearly the full year of the
No, I
treatment, Judge,
mean-
and the appellate division has repeatedly said that someone can be a YO even where they do not comply with that condition.
But it's not just that. He didn't go for his pre-sentence. He literally did nothing that he was required to do.
No, Judge, he completed 1 program, and he was in excellent standing in the Bronx Connect program at the time of the YO adjudication here. But I want to go back to the sentencing court's reasoning. The sentencing court said, if this was a 1 or 2 shot deal with selling drugs, I would be much more inclined to follow through with YO status. It was a 1 shot. The court just misread the indictment. Please read the indictment. Angie Quintero is the named defendant on all of the sales except for the 1 acting in concert with my client.
Counsel, your client pleads guilty to second-degree criminal weapon possession, correct?
Yes,
The judge says, if you do A, B, C, and D, I will give you YO. If you don't, I will allow you to vacate your plea because I'm not going to give you YO, correct?
that's right, Judge.
He doesn't do what he's supposed to do, and he gets rearrested. The judge still gives him YO on that first arrest, correct?
That's right. That's
And
right.
he tells him, if you're going to take a plea here, I'm going to let you know right now, I may not give you YO on the second, correct?
That's right.
And now you want us to use our interest of justice power and give him YO on the second.
Yes, and here's why. Or under an abuse of discretion standard. Again, this court can do either. The reasons for why. Had this happened months later, he would have been in family court by operation of law. So that's one. Second, it was a single sale committed with a co-defendant girlfriend twice my client's age. Clearly a bad influence. She was charged in 6 sales in this indictment. My client only with 1. So when you look at that context, which is a single drug sale, my client was 17, he should have gotten a YO on the drug sale as well. I'll pick this up on the rebuttal. Thank you.
Thank you, counsel.
Good afternoon, Your Honors, and may it please the court. Kalani Brown on behalf of the Bronx County District Attorney's Office. Your Honors, we respectfully request that you affirm the defendant's sentence. He was given all consideration for his YO adjudication.
What was the mitigation the court found to grant him the youthful offender adjudication on that violent felony, the criminal possession of a weapon?
The court found that given the defendant did complete at least 11 months of his program requirement, and given his family history, his family was present in the court. I think that's all. He didn't have any disciplinary issues before he was rearrested. The defense did cite his mental stability, his ADHD difficulties, and so the judge did take all of that into consideration when he adjudicated him a youthful offender. And so, Your Honors, as you've mentioned, the defendant was rearrested just 11 months later, and so regardless of the level of involvement that the defendant did have in the indictment, there was on the face a 20-count indictment where the defendant was charged acting in concert with the co-defendant.
But what about what your adversary says, that the judge abused essentially the judge's discretion because he had incorrect information about how many charges the defendant was actually facing?
Your Honor, that is absolutely incorrect. The judge did not abuse his discretion. The judge, as we all did on the record, had the 20-count indictment that alleged 6 different dates of acting in concert with the co-defendant. And so the defendant, given that information, still decided to plead guilty, and still, as a rebuttal stated for, reasoning his conduct, stated that he was influenced by his co-defendant.
The judge also extended a significantly less sentence than the people were requesting for the new conviction, correct?
Yes, Your Honor. The people did request 2 years of incarceration and 2 years post-release supervision, and the judge still afforded him 90 days of jail until the defendant ultimately violated his probation and was resentenced to 9 months of jail. And so the defendant was given all consideration. He has
Counsel, how should we take into account that the Raise the Age Act was about to take effect, and if it had all occurred a few months later, he would have been in a very different setting?
Your Honor, that law was not retroactive. And so unfortunately, given that the law was in effect months later, it wouldn't have applied to the defendant in this circumstance. But regardless of that information, Your Honor, on the face of the totality of everything that had occurred, the defendant violated each and every condition that he was afforded on his underlying case. And so with violating all of those conditions, he was still afforded a youthful offender status, and he was still given a lenient sentence on his drug case.
Do we know that he would have been in family court on the criminal possession of a weapon charge?
No, Your Honor, it cannot said that the people would have automatically had removed him to family court.
This is a violent felony, right?
Yes, Your Honor.
If he was alleged to have been displaying that firearm in some way, it wouldn't have been eligible for family court, right?
Yes, Your Honor. And so those arguments were not preserved at the sentencing hearing about his ability to to be considered for that act or excuse me, not the, it wasn't applied, but those arguments weren't brought up. The issue about the defendant, his level of involvement in the drug case was not brought up. And so the only thing that was discussed was that he was influenced by the defendant. And so the defendant admitted his guilt at the sentencing hearing, and so it cannot be said that the sentencing court had abused its discretion and stated that if it was 1 or 2 drug sales that it would have been a different outcome. It doesn't necessarily mean that. And so given that it was a 20-count indictment of several felonies where he was charged in counts 1 to 3 and in 19 and 20, it cannot be said that the sentencing court did not look at this appropriately. If your honors have no further questions, I rest on my brief.
Thank you, counsel.
So we heard about some of the mitigation as to the gun offense. I would like to add that there was no allegation that he displayed a weapon. He simply had a gun in his pocket. He was 16 years old at the time. And so there's no question about whether he should have been in family court as to that offense. He was granted YO as to that offense. But we're saying he would have been in family court by operation of law on the drug sale. And so as to whether the sentencing court considered the factors for YO appropriately, the sentencing court did not. It could not have, because it said, I would seriously consider YO here if this were a 1 or 2 shot deal on selling drugs. And it was. The court misread the indictment, which is just a manifest abuse of discretion. And so I would really like the court to focus on that here. Again, John was in excellent standing in the Bronx Connect program at the time of the YO consideration.
He's in excellent standing, but for committing other crimes.
That's correct, Judge. The 1 drug sale here, and we would ask this court to grant him a YO.
Excellent standing, but for being under the influence of someone that you say was a bad influence.
Yes, Judge. I don't know that we can blame him for that. I think that this is someone who is twice his age with whom he was romantically involved. John was 17, his girlfriend was 30. I don't know that blaming him for that is the way we should be looking at this, respectfully. If your honors have no further questions, we'll rest on our papers. Thank you so much.
Thank you, counsel. Thank you both. Delise versus Davis.
May it please the court, Nicholas Calabria with Amity Demirs McManus for the defendant Carla Liza and Sons Paving, Inc. This action involves a tragic automobile accident involving 2 vehicles. The front vehicle was rear-ended by...
Yeah, we know. We saw the photos. So you got a rear-end collision creating a presumption of negligence, of
Correct.
course. Was that rebutted by Davis and Avid?
No, and we're not even arguing that. The whole issue on this appeal is whether the front vehicle should have been granted summary judgment and had the cross-claims and counterclaims dismissed against it just because the defendant Davis was found negligent in this case because he did not have an explanation of the rear ending of the Delise vehicle. And
Isn't that the result of the operation of the presumption?
that's correct. But the question is, does that presumption then automatically, and essentially automatically is what the court almost did, find Ms. Delise was not negligent? Okay, so the second vehicle is negligent, but does that mean the first vehicle wasn't? And I submit that there are questions of fact raised on this record that the Delise vehicle was operated in a negligent manner and that proximately caused this accident.
Right, you rely on the event data recorder in Maritza's
Correct.
car, right? And you say that she decelerated from 29 miles per hour to 5 miles per hour.
Correct.
Where's that in the record again? Tell me, who interprets that data?
That's interpreted by the experts in the case that were neither retained by my client. Let me just check the page references for those.
The crash data retrieval data, doesn't that list the mileage as 15 miles per hour right before?
No, Your Honor. That's just the raw data. It's based on found it now. the affidavit of John Desch at page 509 of the record.
So how does he explain the raw data that says from the car itself, which says right before the accident she was going 15 miles an hour, and how does he explain his extrapolation to no, she was, his accident reconstruction? What is that based on?
Because the accident didn't happen 1 second before the accident.
Okay, so you're saying in 1
In that
second.
1 second, the car continued to decelerate she's
How
applied-
does he explain that?
How does he explain?
How does he, what, based on what?
Based upon, Ms. Delise's testimony that she was applying her brakes in order to bring her vehicle, she was saying to slow it down. At
Right.
first, she said she didn't know
Right.
the speed she was going, she didn't know the speed she arrived at. That all came from the data.
The car tells you what it is, right?
Right, but she said she was applying her brakes, and then she was struck in the rear by the other vehicle.
And your driver said you never saw the brakes, right?
Correct.
So
No, he's not my
clearly,
driver.
I was the driver.
Yeah,
of
the driver.
the driver.
My client was
know.
the...
I'm sorry, I
Carla was
misspoke.
the repair.
I
We had
misspoke.
nothing to do with it.
Right.
We had nothing to do with hiring that expert.
Misspoke,
Okay.
right? But the driver says that the driver never saw the brakes being placed, right?
Correct.
So how is it that she could have been negligent if the driver didn't see her and couldn't see her braking?
But she testified that she applied her
Right, but
brakes.
that's-
The data recorder recorded that she applied her brakes 2 seconds before the accident and had a rapid deceleration in the left-hand lane of the Bruckner Boulevard. The car behind her did not expect that. It's reasonable that in traveling on a road that someone's not going to just automatically jam on their brakes.
But, right, that's what I'm saying. What evidence is there that she jammed on her brakes?
The
She
rate
was
of
braking. There
the
was
rate-
at least 2 brake,
Correct.
right? So where does your expert come up with
It's the
that?
rate of deceleration.
And counsel,
And from that data recording, the data recording is not the end all of the evidence. It has to be interpreted. And that's where the affidavit came from. And I believe that raises a question of fact that should have been decided by a jury in this case.
counsel, the case law does not support that a sudden stop alone is enough to rebut a presumption in a rear end collision.
I'm not trying to say rebuts the presumption of the rear vehicle. I'm saying the front vehicle still has to prove that they were not negligent. In this record, that was not established. And I would point to the case of Tutrani versus County of Suffolk, which is a Court of Appeals case, which is a very similar fact pattern with stopping of vehicles. And in that case, court found that the rear vehicle could reasonably expect that the traffic would continue unimpeded. You cannot expect the car is going to slam on its brakes for no reason.
Again, I don't know where you're getting slam on the brakes, except for the fact, there is no fact in the record that supports that. The record supports that the road was rough.
Correct.
She was braking.
Correct.
So where is it, change the lane and slam on the
It's the
brake?
speed that she decelerates from that's recorded in the data recorder and then interpreted by the expert. That's where it comes from.
Thank you, counsel.
Thank you.
May it please the court, Gerard Ferrara for defendant respondent,
So
Delise.
what about this interpretation of data that shows that she decelerated so quickly down to 5 miles per hour? What do you say about that?
Your Honor, the only thing more tragic about the infant fatality case here is essentially trying to blame the innocent grandmother for the death of the child. The event data recorder essentially states that she's traveling 29 miles an hour, 6 or 7 seconds before the accident, 25 miles an hour, I believe within 5 seconds of the accident, and then over a period of 4 seconds decreases to 5, 25 to 5. Not 100 to 1, not 75 miles an hour to 10. She's driving a reasonable 25 miles an hour in a, I think, 40 mile an hour speed zone. So she's reasonably taking precaution for the milled roadway. And the only reason this accident occurred, because the truth is, if co-defendant Avid did exactly what respondent Delise did, none of us would be here right now. The fact is, She sees a manhole cover raised in front of her. She's traveling again 25 miles an hour and reasonably slowing because she's concerned, as any reasonable person would have in this case, especially with her granddaughter in the car. She slows her vehicle. Avid Waste, driving this monstrosity of a garbage truck, whom the DMV in their fatality hearing, the NYPD Collision Investigation Squad, all found was speeding in the right lane.
You know, you do a good job unpacking that in your brief, but so you're saying that, in fact, the data does show that she eventually was down to 5 miles per hour?
Correct. She's slowing. No one's disputing that. And to Your Honor's point, stopping short, absent certain specific reasons, is not an argument for negligence. In fact, to address counsel's claims, because he argues in his reply brief that I don't distinguish his case law, so I will very briefly distinguish it since it didn't need to be distinguished in the respondent's brief. Stopping short essentially comes down to two things. Whether you're mid-block or you're in some scenario where you shouldn't be stopping, like a light that turns green and you just immediately stop for no reason, or you've changed lanes abruptly in front of somebody and then you slam on your brakes. Neither are the case here.
That's what I'm asking you. So you're saying that the evidence shows that she slowed down and was braking, not that she hard braked and switched.
Correct, Your Honor. She's reasonably braking to address the manhole cover that she deems a danger. She's not an expert that has engineering expertise. She's viewing it at a downward angle as she's driving in a vehicle. She's not, again, doesn't have a measurement, doesn't have time, doesn't have hindsight, engineering degrees where she can measure this all and determine, oh, it actually wouldn't have damaged the vehicle. That's not the standard. The standard is she reasonably considered that she had a dangerous impediment in front of her. She took reasonable precaution to stop, unlike Avid, who sees a car stopped in front of him, and instead of slowing or stopping himself, which would have avoided this whole accident, he fails to observe Delise in the lane next to him, veers to the left, and then slams into her rear so hard that he drives on top of her car, crushes the rear, slams her into a concrete pillar, and still has the momentum to push her 130 feet down the road. That's nearly half a football field. That's how fast this truck hit this poor woman, and of course, killed her infant granddaughter. So again, the fact remains, and again, just to address Tutrani quickly, this landmark case that stands for this stopping short factor. In Tutrani, the police officer was doing 40 miles an hour, changes lanes because he fails to see that traffic is stopping ahead of him, changes lanes and slams on the brakes, exactly as I just addressed, one of those stopping short instances. He changed lanes and went from 40 to 1 in 2 seconds. That is not the case here. There's no evidence whatsoever that Delise makes any lane change. And again, she's doing 25, not 100, not even 40. She's doing 25 and slows down to 5 when she's rear-ended by a vehicle that's, again, the co-defendant's vehicle. No one disputes that. I understand counsel's points. Of course, he's here to advocate for his client, but I would argue that the lower court got it right. There is no basis whatsoever to turn this tragedy into something even worse by bringing the grandmother back into this case when she was reasonably found to not be negligent, again, for stopping and being rear-ended. And unless the court has any questions, I'll rest on the briefs.
Thank you, counsel.
Thank you, Your Honors.
The point is the decision made by the court below essentially said that because Davis was negligent in rear-ending the plaintiff's vehicle, the complaint against the cross-claims and counterclaims should have been dismissed based on that fact alone. That's not the law. We have a record here of how she was operating her vehicle. We have the data recorders and the affidavits of the experts giving us exactly what was going on at the moments before the accident. And quite simply, Davis's negligence in rear-ending the vehicle does not absolve her of negligence in rapidly decelerating her vehicle.
You're saying the simple fact of decelerating her vehicle to avoid a uncovered manhole cover.
No, it's not
is
uncovered.
Negligent?
Yeah,
It's up, it's raised, right? No one disputes it. We saw
right. We
the
have a
pictures.
milled road, and there's
it's up
testimonies
and
that it's an
raised.
inch to an inch and a half
So
above.
you're saying the fact that she decelerated so as not to go over that in itself raises an issue of negligence?
Yes, it does. How
In
is
the
how's
context
the
of a
vehicle
rear-end
be harmed?
collision?
How does the vehicle be harmed?
Counsel, can
wait
you
a minute.
ground it in the context of a rear-end collision?
Am I grounded in it?
Yes, ground your argument in the context of this being a rear-end
Yes,
collision.
Yes, it's a rear-end collision.
Isn't the car behind you
there's certain-
supposed to be far enough behind you?
Yes,
so
I
that it
agree
can
with you.
slow?
I agree 100%. I'm not saying Davis isn't negligent, but I'm saying you can't say his negligence, the front vehicle is automatically not negligent because the rear vehicle was.
no, it's not
And that's
autom-
what was decided in this decision, Your Honors.
It's not. It's that the fact that she slowed her car down to avoid bouncing over that can't be considered negligence. That's what it is.
I don't think so.
Okay.
And again, we have this rapid deceleration, and it's not as, it's right in the record. She's 5 seconds before the accident, she's
Counsel,
traveling
we have
29
your brief on
miles
that
an hour.
point. We have your brief on that
Okay.
point. Thank you very
Thank
much.
you.
Thank you both. Torres versus Kora Realty.
Good afternoon, Your
Please.
Honors. Monica Romero for defendant appellant. I would like to focus today on the fact.
Could you move the mic closer to your mouth? Thank
Is
you.
that better?
Yes, much
Okay,
better.
got it. I would like to focus today on the fact that there has not been a breach of duty in this case. The plaintiff alleges a breach of duty in the form of two defects in the building. One is lighting, and the other one is handrails or lack of handrails in the landing area. Now, the first alleged defect, plaintiff conflates with optical illusion and lighting, but if it's not a logical argument, right? Like if the plaintiff cannot see, then she cannot be optically confused.
I thought she distinguished between optical confusion and a lighting condition.
She did not. In fact, throughout her testimony, she consistently identifies lighting as the issue. When she's asked, why couldn't you distinguish the steps, she always goes to, it was dark. When she was asked, did you have any issues previously when you used the stairways before, she said, only the lighting.
Well, didn't she also say like all the stairs are painted the same color and it's hard to tell one from the other?
Yes, and then
So I mean, isn't that the whole optical
because
illusion?
when she was further pressed about what she meant by that, she said it was dark, right? And
Okay, but the fact that she said more things doesn't negate the fact that she said all the steps are painted the same color and it's hard to differentiate. And because it's dark, it's hard to differentiate one from the other, right? That's what she testified to. I don't
right,
know.
and I think it's
Might
followed
not be
up
true
always
or
by
might
an
be.
explanation that it's the lighting, and we cited it in our briefs.
But isn't it coupled together because of the way that the stairs are painted coupled with the lighting?
We disagree, Your Honor. We think that it's we broke it down in our brief, right? Like, and this is not really, it's not really optical illusions is anything, right? Like it's actions that fall under changes of level in the floor. And one category of that can be optical defects, and then other categories of that can be lighting, can be lack of handrails, right? Like it can be all of those, but those are defects in and of themselves. They don't just conflate into one consisting of optical illusions. An optical illusion refers to an intrinsic characteristic of the steps, whether it's color, patterns, texture, right? Like it has to be about the step specifically. But in this case, we highlighted in the brief every single time that the plaintiff explained what caused her fault, she kept going back to lighting.
Well, didn't her expert say that the uniform gray color could have caused was a cause of her having a difficulty transversing those stairs?
He just stated
Because
that
based on her testimony, all the stairs look the same, and I mean, look, that's the testimony, right?
right, but it's a conclusory statement from the expert, right? He doesn't explain why buildings are required to paint steps different colors. He doesn't cite to any building code saying, hey, building owners are required to paint steps in different colors. They are required to
Well, that's
have
not the only.
Because it's a common law concept and not based solely on regulation. The idea of optical confusion is in part a common law concept. So She doesn't have to rely on specific regulations.
Right, but for their expert to state that steps painted in the same color constitutes a defect, then that has to be based on something, right? Like it has to be an industry standard. For example, if someone falls in your stairs here, they're all the same color. Are you, in violation of a building code? I don't think so, right? Like there's no duty for that.
She's not alleging a violation of a building code. She's saying it created optical confusion, which is a common law concept that was
Right, the justice's questions related to the plaintiff expert and the testimony about it, and the testimony about the color of the steps, not about her claims. And if I may, defendants established that there are no lighting defects in the building, right? Like our expert testified that not only was the building compliant with the applicable code, the 1938 New York City Building Code, but also with the 2014 New York City Building Code. And the report includes the testing that the expert conducted from the first stairway to the second stairway, showing that the light in the building was, or from the first stairway to the second stairway, is measured as 1 foot candle. Per the, as required by the 2014 New York City Building Code. In opposition, the plaintiff submitted its own expert report that conclusorily stated that the lighting was dim, but it didn't state why.
Right. There was no measurement. You make that point in your brief that there was no measurement of quantum of lighting in the staircase, right? That's your point.
Well, there's no
He just gave his own subjective idea that it was dim.
Yes, but it simply states dim. It doesn't state, well, it doesn't provide a comparison between a code compliant building and this one, industry standards, or it didn't even provide its own testing of the lighting in the stairway.
Thank you, counsel. You have time in rebuttal.
Good afternoon, Your Honors. May it please the court, Michael Zhu, appellate counsel to...
So you can see there's no actual notice here in the record.
I'm sorry, there's no...
There's no actual notice of the condition, correct?
Correct.
Okay,
There's
so
no actual notice.
what's constructive notice?
The constructive notice is based on a testimony of Cesar Morales, who says that, there are no paints, there's no highlighting around the stairs, there are no markers around the stairs. I don't know if there's lighting in between the steps. There's one in the flight above and one light bulb in the flight below, but there are no windows that would allow natural lighting in there. So the building was certainly aware of these conditions, and as Justice Michael alluded to before, it's a confluence of all these conditions that give rise to the claim here. It's not just there was dim lighting and I fell. It's not just that it was all painted the same color and I fell. It's because the lighting was dim, because she had visual impairments.
Just stopping on lighting, I understand what you're saying, that there's a matrix of factors here, but Mr. Faranek, who's your expert, did he do any quantification of the lighting?
No, he did not.
Does he have to?
No, he does not. Because the lighting itself...
One second. For an optical illusion, an optical confusion. Close, but not right there. For an optical confusion, that may be. But for an inadequate lighting claim, a standalone claim, absolutely you have to have some kind of better... Right? Are you making a standalone?
I absolutely agree with you, Judge. I'm not going to stand up here and say...
Okay, so there's no standalone inadequate lighting.
No, but it's the fact of...
Okay, and how about the handrails? There's no... The handrails, it seemed to me, you have to give up too, because you're...
I'm not arguing that they should have had handrails.
Oh, you're just talking about the confluence of all those factors with creates the condition for the optical confusion.
Correct.
Okay.
Correct. Yeah. And it is those factors that has to be considered and was considered by the trial judge in denying the motion.
Into the fact or the allegation that your client had her eyes dilated at the time.
I'm sorry. Say that again. What?
Your client had her eyes dilated at the time.
She's a glaucoma patient. But as I said in my respondent's brief, it's the eggshell plaintiff. You take your plaintiffs as you find them. The fact that she had her eyes dilated at the time made it more difficult for her to walk, and that exacerbates the problem of the confusion.
Yeah, but I don't
that
know
she
if
was
that's an
confronted
apt comparison, because eggshell plaintiff is just, it doesn't set the standard for staircases. Like what we're talking about here is what is reasonable in terms of the
Correct.
maintenance of a staircase.
And what she was confronted with, even
she
based on
might
a
have-
reasonable person standard, is a hazardous condition. Again, based on all these conditions that happened.
But she might have been comparatively negligent in not taking an elevator or in.
The elevators were
purposefully-
broken, so she couldn't take the
Oh, but okay, but I'm saying that doesn't relieve her of her obligation when her eyes are dilated to use different care than maybe someone whose
Correct,
eyes
Judge.
weren't dilated.
I'm not the one moving for
Right,
summary judgment
exactly,
here. So I'm the one that's opposing, so it
That
wasn't like
fact
her to
alone
overcome.
doesn't make her the proximate cause of her own accident, right?
She's not the sole proximate, because there are concurrent causes that may have contributed
Were
to
there
this.
also inconsistent risers on in the stairwell?
Yes, there were, but that really, I don't think that played any factor in her, because it's her coming down the steps, and then once she comes down the steps, she makes the right turn. And it's after making that right turn is when those two intermediary levels were, because they were painted gray, she couldn't tell that there was a step in between the two intermediary landings. And if you look at page 564 of the record, the picture, that shows it exactly. You just have to rotate your vision. She's coming down the stairs on the right-hand side, and what's in front of her is what she's confronted with. So in a staircase where there's dim lighting and it's all painted the same color, to her, it's the same, it's all one flat surface. And she takes a step, not realizing that there is a step, and that's why she testifies that she fell on her her tippy toes, because her toes were pointed down at the time and she didn't realize that there was a step there.
Thank you, counsel.
Thank you.
Your Honors, if I may finish my initial argument. So the second defect that they alleged was breach was, as you mentioned, Justice, lack of handrails, not on the stairways, because both expert reports conclude that the building is complying with the handrails on the stairways, but the argument is in the landing.
Yeah, but I think counsel concedes that that's not going anywhere.
And then, so based on that, I think that plaintiff's expert report does not raise or reveal any issues of fact here, really. The building doesn't have any defects. And on the other hand, the Court of Appeals has held that an individual who's traversing a passageway with a descent has a duty to proceed with caution and not move blindly. And they have a duty of care. And in this case, the plaintiff has failed to establish that she proceeded with any caution, especially when she had used the stairway 5 to 10 times before.
He's not moving, you're moving. So
Right.
that really doesn't, that's neither here nor there. That,
Right, but she was
just about you.
got it. So she had been there 5 to 10 times before. She had used the stairway. There had been no issue.
Yeah, but that doesn't address whether you were negligent. That only addresses whether she was negligent.
Well, but given the fact that there had never been any complaints from the residents, never any incidents from the residents, and there's an expert report showing that there are no defects in the building, I think, and given her medical history, it's unfortunate, but we can conclude that it was her visual impairments here that played a role in causing her fall. And thus, I don't think that they have shown, any facts that can show that there has been a breach of duty, and thus they cannot move on to causation. And unless the panel has any question, I rest on our briefs.
Thank you, counsel. Thank you
so
both.
much.
Mondragon versus Trustees of Columbia. Justice Rosado is recused.
Good afternoon, Your Honors. May it please the Court, I am Richard Ashnault from the law offices of Kevin P. Westerman for the third-party defendant appellant Absolute Plumbing and Heating Corporation. Your Honors, what we have here is a case where the president of Absolute produced the records relating to the repairs that were done.
Yeah, but Mr. Status did admit, did he not, that the relevant contract, which was a task contract, order agreement, that he could, the city, or Columbia rather, could direct him orally to do things too, right? Not just pursuant to invoice.
Yes, it was a task-based contract.
But also it could be an oral direction from Columbia.
Correct. Which would mean it wouldn't show up in a task order, but it would show up in invoices. They weren't in the business of doing work for free.
Okay, right.
So the invoices that were shown, he went through in his testimony in great detail as to what those things were. In the 2 months before the accident, there was some work that was done on the domestic hot water system. That ended up being an electrical problem, and they put in a flow switch. According to his affidavit, that did not include any pipe replacement, removal, or installation.
So if there was work that didn't require purchase of particular items, would there necessarily be any written record of it if it was an oral order and no invoices were incurred?
Well, there would be invoices incurred. They would be required to pay for the work that was done, but that might not show up in a task order that was issued before the work was done. It would still be invoiced. So all the invoices were produced for the work that was done in the 2 months before the accident. None of them included any removal or installation of any pipes. And the plaintiff says...
You also submitted Nelson Falcone's testimony, right?
Sorry?
You submitted Nelson Falcone's testimony?
Falcon, yes.
And wasn't that sufficient to potentially create an issue of fact, placing Absolute in the basement during the relevant period?
Well, they may have been in the basement, but he did not testify that they did any work that involved the installation or removal of any pipes before the accident.
Storage of stuff, storage of things. I mean, I know that the items that allegedly caused the fall, you say at least the netting part is fictional. There is no such thing as plumber's netting, but there were also pipes involved. And in other words, you were allowed to store stuff in the basement, which allegedly some stuff that perhaps caused by vibration went against the staircase and caused the fall. I know it's all sort of attenuated.
Well, the stairway was not the stairway. Where the stairway was outside. So even if there was storage of materials inside, these pipes were outside.
It wasn't an interior staircase.
I'm sorry?
I thought it was an interior staircase.
There were two staircases. This occurred in the exterior staircase.
Which one did the plaintiff fall on?
The exterior staircase.
Okay, thank you.
So, and that was another thing that was in Mr. Stathis' affidavit, is that there was no pipe, there was nothing ever outside. There was no storage of any materials outside, excuse me. So all of the work that was done, he went through again in detail. There was work done on the drains both inside and outside the building. That was just snaking the drains because they were clearing them out. Did not involve the removal of any pipes, installation of any pipes, anything like that. So what we have here is pure speculation as to where these pipes that plaintiff tripped over came from. You also have...
He doesn't say he tripped on pipes. He said he tripped on some kind of netting type of material.
the netting...
I mean, I don't know what it is, but it could have been brought in by your people. It could have been like debris that they brought in. They were there, and...
They were not there on the day of the accident.
Not on the day of the accident, but right before the accident, they were there.
3 days before the accident was the last time they were
and
there.
it is not, no one can say that they didn't leave anything there at that period of time, did they?
The plaintiff did testify that it was pipes that he tripped on, and they were wrapped up in this, the
I
pipes
thought he
were
said
wrapped
it
up
was
in
like
this mesh netting.
Oh, I thought it was just the netting.
No, it's pipes. He testified as to these drainage pipes that were...
The plaintiff also testified that it was your client's materials that were left behind, or at least that he saw materials left behind.
He never testified that he saw my client using any materials at all.
No, not using them, but that they were left behind in a location.
He called them plumbing materials. He has no idea who put them there, how long they were there, or anything like that. He just said it was plumbing materials. according to the president of our company who did all the invoicing, there was no pipes that were used, installed, removed at any point in the 2 months before the accident occurred. There was other work that was done, did
Right,
not
but we're
involve
talking
the.
about a motion for summary judgment, and where, in fact, the plaintiff says this, does that not raise a question of fact?
I don't understand how it can raise a question of fact as to our
Because I think,
work.
didn't the plaintiff say he saw your guy's truck there on the day of the accident?
No, he testified he did not see our guy there on the day of the accident. He initially testified that he saw plumbers, he believed plumbers did work when he went there a week before the accident, or 2 weeks, depends on which testimony you listen to of his. He did not see any plumbers doing any work the first time he was there. He later testified, oh yeah, I did see people from Absolute.
Well, he did testify to it, so that means he testified to it.
He did not say that he saw them doing any work in the basement at that time. He testified that he saw, well, first of all, his initial testimony was he did not know who the plumbers were when they did any work, and he never saw any of the plumbers do any work. He then, potentially realizing that that didn't help him very much, changed his testimony completely, and he did say that he saw Absolute people putting.
I just have to ask, is there no indication who brought these pipes in? Doesn't Columbia have any records from anybody? These pipes didn't appear like
There is no documentary evidence of any work that was done by Absolute or anyone else involving pipes in the 2 months before this accident, the installation or removal of pipes.
Okay.
Thank you, Counsel. You have time to rebuttal.
Thank you.
May it please the court, Mary Azzaretto for the property owner, Columbia. Absolute essentially asks this court to make a credibility determination of plaintiff's testimony, and that is simply not the role of this court.
Let me just ask you two questions. One, was there plumbing work done in the basement?
Yes.
Involving pipes?
There was plumbing work done in the basement involving drains, involving numerous projects. We don't know specifically what the pipes and the mesh material could have been used for. And just to correct something that counsel said, plaintiff did not testify that he tripped over pipes. He testified that his foot became entangled in mesh that was attached to pipes. So there is a difference there. But essentially, there's nothing incredible about a worker alleging that he was caused to trip over material brought in by a company that was seen, known to be, and documented to have been doing work there not once, but 5 times at or around the time of his accident.
But I guess what the company says is we didn't bring in any pipes. So if something was attached to the pipe, like the wrapping around it, it wasn't us because we didn't bring in any pipes.
They did say they didn't bring in pipes. However, plaintiff's counsel said he saw the pipes and the mesh there before. Plaintiff said that he saw the pipes there and the mesh before. Plaintiff testified that he saw them doing work. He saw them wearing their shirts. He saw them in their van. There's an abundance of testimony.
He's saying that he saw them bring in pipes?
He's saying that he saw the pipes on the premises, and on prior occasions, he saw them there, and he knew it was them based upon their trucks, based upon their shirts. Just because he didn't actually see them performing that work doesn't...
No, we're just talking about who brought the thing that caused the plaintiff to fall.
I don't know, but it's not my burden, Your Honor, it's theirs. And they also don't know who brought it in.
Well, they say we didn't bring in any pipes or anything attached to any pipes.
They did, but plaintiff says otherwise. And the fact that
What he says otherwise is regard to pipes on a different occasion, right? But not...
Well, he knows that there were pipes there on a prior occasion, and he knows that Absolute was doing work on 5 occasions that involved plumbing. He also knows that the material he tripped on was plumbing material. He knows that based upon his years of experience with what he does. All those things are classic questions of fact that a jury needs to determine. And the fact that there's no reference in the written records to those actual materials, it's of no moment. It's undisputed that
orders were given verbally, and that any invoices generated as a result of those verbal orders would not be provided to Columbia. So while it's wonderful that Absolute says, well, I don't have anything that says that, there are questions and as to whether or not that is the case that a jury should determine based upon the testimony of the parties.
There were verbal orders, work orders that were done that did not get reduced into an invoice?
They were reduced to invoices, but those invoices were never provided to Columbia. So Columbia couldn't do a search and determine that anything that was verbally ordered wasn't done because we don't ever get those records. So we should have an opportunity to question the witness about that at the time of trial.
Didn't you pay for the work?
We paid for the work, but it doesn't mean that every single piece
No,
of
who got
mesh.
the invoices?
Excuse me?
Who got the invoices, if not you?
The invoices that were generated as a result of any verbal orders were not provided to Columbia. That was the testimony.
Oh,
and that's
who did they go to?
They stayed with Absolute. And there's testimony in the record to that effect that anything that was ordered verbally, I'm not talking about the job in general, obviously they would get invoices, but anything ordered verbally, which everyone agreed was something that was done at the time of the accident, would not be reduced to a writing that would be provided to Columbia. So without that...
How would they get paid then?
Yeah, that's what I'm curious. How would they get paid?
Well, I guess it depends on what exactly it entailed, what it was. Again, it's all speculation, and they had the burden of establishing that there was no questions in that regard, and there are several questions in that regard. And for that reason, the court was correct in holding to that effect.
Thank you, counsel.
Thank you.
Good afternoon. Denise Rubin for plaintiff respondent Mr. Mandron. Let me clear something up right now about pipes. This is the testimony of Mr. Falcon at his deposition. Quote, their work was limited to because we were cementing the floor. We had to replace some of the floor drains, some of the piping for the floor drain, and I believe they might have removed some obsolete plumbing, obsolete piping in the space as well. That is in the record at 895, lines 7 to 15.
So there was testimony that they were working with pipes.
There was.
That was Mr. Falcon's testimony?
That's Mr. Falcon, yes.
Okay, he's from Columbia.
Pardon?
He was Columbia's
Yes, he is
representative.
I think he's the building manager, but he's responsible overall for that building. At the time, and I also think there's a question about, counsel said that this was an exterior staircase. My understanding is that it was interior to the basement, from the street level to the basement, about 6 or 7 steps, iron, steel, metal in some way. I understood it to be inside, from the street level down into the basement.
Right, they're leading to the basement. This
Right, that was
exterior
my
they're kind of exterior, I guess you could call them exterior, because they're leading to the basement.
Right. And talking about what happened, Mr. Mondragon said that as he was going down the stairs carrying approximately a 60 to 80 pound big garbage can full of wet cement on a staircase that vibrated and or shook every time he put a step down because of this heavy load, that his foot became entangled in this, what he described as plumbing mesh. Those were his words. And asked how he knew that, he says, well, my experience, and I've seen plumbers working with this before. And he was asked, well, wasn't there mesh on the floor where you were laying the cement? He said that was different. The mesh on the floor, generally speaking, is going to be either like bars, rebar, something like that when you're laying cement down. But he said that it was different, a different material. And then the inquiring attorney tried to get him to be clearer, and he was asked whether the pipes were separate from or entangled within the mesh. He responded saying that the pipes were materials next to, and I have this in brackets, so I think he used a different word, but the mesh, next to the mesh, the pipes, it was with the pipes, and that's at the record 352 to 353. Again, I would concur with Columbia's counsel. This is a motion for summary judgment. We don't need to prove that they were on site. We don't need to, in fact, it's not our burden of proof on the motion. It is theirs. And there are clearly questions of fact here. That's the only issue. Was there a question of fact? Now, on the motion, I'm sorry, I know my
Please continue.
time is up. Their argument had been, as I understood it, that there was credibility issues, that Mr. Mr. Mondragon's coworker said, I didn't see him fall and he wasn't carrying cement. You know what else he said? It was a wooden staircase.
Okay, thank you.
It wasn't. So.
Thank you very much.
And thank you.
A couple of issues here. There was a comment made earlier about the plaintiff testified that he saw Absolute there 5 separate occasions. He was only there once before the day of the accident. It's undisputed that Absolute was not there on the day of the accident. With respect to the Mr. Falcone's testimony.
That wouldn't necessarily relieve them of liability if they had been there the day before and left pipes around.
I'm sorry, I couldn't.
That wouldn't relieve them of liability if they'd been there within the previous week and had left pipes around.
Right, but according to the testimony and the invoices, there was no pipes that were used on any of that work in the 2 months before. There was a question about Mr. Falcone's testimony. Mr. Falcone was very clear that he could not pinpoint when the drain work was done in the basement relative to the plaintiff's accident. He was very clear about that. That's at 1017 to 1018 and 1022 of the record. He testified that there was work done on the drains. It was done by Absolute. He did not know when it was. And according to Mr. Stanthus, that was done, that it was afterwards. It wasn't in the 2 months before the accident. With regard to the plaintiff's testimony, the issue there really is self-contradictory testimony cannot, it should be ignored by the court. And there's
That's a heavy lift, though, counsel, in general. Usually, as you know, it's left for the finder of fact to determine whether it's so unbelievable as a matter of law. That's a hard finding for us to make.
But it is a finding that the court does make on occasion, and there's the Laughlin case, and that's been cited by this court several times. So.
Okay, thank you very much, counsel.
Thank you.
Thank you all. People versus Cabrera. Hold on a moment, counsel. Thank you. You may begin.
Good afternoon, Your Honors. Nathan Brown with the Legal Aid Society on behalf of Appellant Mr. Cabrera. The prosecutorial misconduct before the grand jury was pervasive, willful, and egregious. Mr. Cabrera readily admitted to the misdemeanor offense he committed as soon as he was arrested. Yet the prosecutor chose to seek an indictment for robbery for which he did not have sufficient evidence. In the face of this lack of evidence, the prosecutor falsified a statement that Mr. Cabrera gave to the district attorney's office after his arrest and used that statement to establish the missing element, to impeach Mr. Cabrera's credibility, and to avoid giving a justification.
We've got to deal with the waiver issue. You need to deal with the waiver issue right, front on. I mean, was there a waiver by the plea?
No, neither the appeal waiver nor the guilty plea prevent the court from reaching this issue because both of those hurdles are not an impediment when there's a jurisdictional issue such as here, or where there is a right affected of a constitutional dimension that goes to the heart of the process. We have both of those issues here. One is, as in Pelchat, a indictment that is based on misconduct, or in Pelchat, the failure to correct false testimony, but here it was the prosecutor himself who created the misperception, and that was deemed.
They dismissed the top count, right, which was Rob 1.
He dismissed it, admitting to some of the lack of evidence in this case. The court also addressed the fact that there was missing evidence in this case. As far as the constitutional dimension aspect goes, the grand jury process is itself a constitutional process.
But you agree that not every error arises or
or alleged error rises to the constitutional.
Certainly the case.
And in this instance, your client got to testify, right? And he clarified what he meant by the statement, did he not?
He stated that he did not say what the prosecutor said that he said, but the Court of Appeals has said that that is insufficient because this is in People v. Houston. The office of the district attorney carries with it weight. And so this is not an even playing field in which my client saying I didn't say that and the district attorney saying something to the contrary are even assertions. In the Houston, the Court of Appeals said that the great obligations that the district attorney has in these proceedings is because there is a power and authority to their office that can be misused to mislead the grand jurors, and that is exactly what happened here. By falsifying the statement Mr. Cabrera gave, the district attorney put his hand on the scale. He reinforced that in his instructions to the grand jurors, noting that our client was, he gave the impression that he was lying in the initial testimony and then put his finger on the scale again, saying that my client is an interested witness under the circumstances there, pressing.
Well, isn't he an interested witness?
Certainly, and that's a standard
Why is
instruction,
that
but context is important.
Why
Context
is
is
that
important.
misconduct?
Context is important, where you've already had the prosecutor misrepresent the statements that my client gave and then pointing to them again to say that of course he's lying, when in fact it was the prosecutor who was lying. So I think that that those taken together reinforce each other, despite the fact that it is a standard instruction. If the court has no other questions, I'll reserve for.
Did you talk about the appeal waiver?
Yes.
Or just the same arguments apply
It's the
to
same
that?
standard in a case like this, that a jurisdictional issue and an issue involving a
What
right
about
of
People
constitutional
versus
dimension.
Correa, though? People, there we held that a waiver of appeal could mean that he wasn't able to raise this issue of prosecutorial misconduct in grand jury.
Certainly, and there are certain instances in which the individual issues are not raisable on appeal, but we have Court of Appeals decisions, multiple that we've cited, Pelchat, Hansen, Houston, which all hold that issues of a constitutional dimension rights of a constitutional dimension survive appeal waivers, they survive guilty pleas jurisdictional issues, and we have raised prosecutorial misconduct here that are similar to those cases. I mean, in Houston, the issue was, one of the issues was reasonably similar here, where it wasn't an evidentiary issue, it was the prosecutor making statements in their questioning of the witnesses, and that's exactly what we have here, the prosecutor making a statement to a witness that is a misleading and willful misrepresentation of that witness's statement.
Thank you, counsel. You have time in rebuttal.
Good afternoon, Your Honors. My name is Brian Wattoon on behalf of the Bronx District Attorney's Office. Starting with the forfeiture and waiver.
Let's start with conceding that it was a mischaracterization of his testimony, correct?
I think it was an incorrect premise, of his.
It was improper.
It's improper, incorrect. We concede that that's not what he had said in his videotape statement. But there was merely a question, and the only evidence before the grand jury was defendant's answer, which was denying that he had said that. And the prosecutor promptly moved on from that isolated question with the improper.
Question is, did that statement significantly impair the integrity of the proceeding?
Under the extreme and exceptional standard that the courts have erected and the statute has erected, you're not even in the same ballpark. My adversary keeps referring to cases like Houston and Pelchat, where, as this court has described Pelchat, the entire indictment was obtained based on perjury. There was no evidence of criminality other than the
In this
perjury that was
case,
presented.
he admitted to the conduct, right?
That's right.
So what was brought before the grand jury wasn't just this one we'll call it, for lack of a better word, mischaracterization of his testimony, right? It was more than that supported the grand jury's finding, right?
Of course, and the notion that the only evidence of the robbery counts, at least that my adversary keeps harping on, was somehow baked into this question just is simply not true, given that you had the loss prevention officer testify in front of the grand jury that defendant pulled a knife on them. And just to go back to the waiver and forfeiture issue,
Wait a
you
second.
can't.
And he testified before the grand jury, yeah, I took the 2 headphones without paying for them, correct?
That's right. He says,
There's no doubt that that testimony was before the grand jury.
correct, yeah, his own.
So it's not just the mischaracterization, I didn't know who these 2 guys were, that supported the indictment, right?
Yeah, absolutely not. You have the loss prevention officer.
The first count.
The first count, right.
That he used physical force, right?
Right. We have the loss for the physical force and the knife. We have the actual testimony of the loss prevention officer. And just to clarify, and defendant didn't present, a choice kind of between 2 evils, which is what justification gets at. He said, I didn't have a knife. Like, this didn't happen. It wasn't that he said, yeah, I did pull a knife to protect myself, but only because I didn't know they were loss prevention officers. So the choice that he presented by his own testimony was not the choice that, in the way that defendant's currently framing the issue on appeal. He said, didn't happen at all. I took the merchandise, I left. Loss prevention officer says he took the merchandise, and when they confronted him, he pulled a knife. So as to the appeal forfeiture by the guilty plea itself, the only case that an appellate court has ever held, and since the 40 years, it's never found it again, this court, any of the other departments, or the Court of Appeals, that a claim of prosecutorial misconduct in the grand jury was not forfeited by a guilty plea was Pelchat. And as this court, as I've already discussed, this court has readily distinguished Pelchat, as the Court of Appeals has, and it's kind of a one-off, pretty unique factual circumstance in which the only evidence of criminality that the prosecution presented and knowingly presented was perjured. As to the the second aspect that my adversary refers to of claims that go to kind of the heart of the process, there's no magic wand where you kind of say that something's in the Constitution, therefore it goes to the heart of the process. There are only 4 claims that have been found to survive a guilty plea. That's illegal sentence, constitutional speedy trial, double jeopardy, and competency. None of those are at issue here. And the Court of Appeals has expressly held that even if those survive a guilty plea, you can waive double jeopardy. So there's no reason that you should not only expand the universe of non-forfeitable claims, but also non-waivable claims here, when for the past 40 years since Pelchat, this courts have been careful not to do that.
Thank you, counsel.
Thank you.
I will just start with.
Also, can you respond to his argument regarding other evidence of criminality?
Yeah, so I can start there. So he did not admit the conduct that he was indicted for. He admitted to conduct that would not constitute a felony. As I'm sure this court is aware, criminal laws have some overlap. So the fact that he admitted to petty larceny does not mean that he admitted to robbery. In fact, he denied committing robbery. There was some misunderstanding, it appears, as to what his testimony was relating to the interaction with the security guards.
But let me just interrupt you for a second. May I just ask you, but that was not the only evidence. The prosecutor's mischaracterization of his statement was not the only evidence as to the robbery, right? There was.
It was the only evidence as to robbery.
How about the loss prevention guy who said he took a knife?
In dismissing the top count of the indictment, the district attorney admitted that there was no knife. So it was repeated again here, but he admitted.
I'm just saying that wasn't the only evidence that was submitted by the district attorney.
What is required to support robbery is my client's knowledge that the people he was using force towards were attempting to regain or prevent the property that he had stolen. That is the only evidence, my client's statement is the only evidence that was presented for that. The loss prevention officer did not admit to having clothes that identified him as a loss prevention officer. He did not testify to having identified himself verbally as a loss prevention officer. He admitted to wearing plain clothes. The security video shows that they were wearing plain clothes. The judge at the plea hearing sort of acknowledges the argument below that my client held a belief that he was being robbed by two strangers and that these were they were not police or security guards. So the mischaracterization of the statement is the only evidence that would support a robbery conviction, because there was nothing else other than his admission that he stole the property, which again is petty larceny, and why they should not have been in the grand jury in the first place.
Thank you, counsel.
Thank
you both. Richardson v. Garley.
Pardon me. Good afternoon. May it please the court. I'm Annette Hassapidis, appearing for the plaintiff in this case. The court respectfully erred in granting summary judgment here. As an aside, there is a trial date set against Dr. Garley for May 15th. Dr. Garley is still in the case. I didn't want there to be any confusion since he is not a party on the appeal. It is undisputed in this case that the imaging of my client only showed that she had a rectocele, a cysterocele, and an enterocele, that there was no internal prolapse detected on the imaging. And in fact,
But didn't Dr. Garley say, I thought it was Dr. Garley's testimony that he said to Dr. Key that they would determine during the surgery whether there was an internal rectal prolapse, and if there was, then Dr. Key would address that.
Dr. Garley testified that this was not going to be his call if there was a potential resection, and he made the referral to Dr. Key.
Right.
Right.
And the expert affidavit, this is a condition that you can find out from during an operation, not something from basically like a physical examination.
Well, actually, to be clear, there was no expert testimony that it is appropriate to determine whether or not someone has an internal prolapse intraoperatively. There's no expert testimony to that effect. What the testimony from our expert cited to a colonoscopy of my client 5 days before she met with Dr. Key, and it showed no internal prolapse. So we have no indication of an internal prolapse, and Dr. Key does not perform any testing during the consultation or before the surgery to confirm that there is one. It is our...
You don't dispute that during the surgery they found that they identified there being an internal prolapse?
Well, we disputed A, and then our expert says further that even if there is an internal prolapse, that's non-surgical. An internal prolapse is a rectal prolapse that is yet to occur. And let's be clear, the three conditions my client had, the rectocele, the cysterocele, and the enterocele, tongue twister, all affect a pressure on the uterus, the tissue that collapses onto the uterus. The internal prolapse and the rectal prolapse affect the tissue of the rectum. So we're talking about two different areas, so to speak, in terms of where the pressure is. But in any event...
But the injuries that she's complaining about, doesn't those injuries go to the use of the mesh with regard to the other element of the surgery and not the fixing the internal prolapse?
Well, again, assuming there was an internal prolapse, again, that's a non-surgical issue according to our expert. And we raised a question of fact as to whether or not it was appropriate to go forward with the procedure.
Right, but your injuries that you're alleging have to do with the placement and usage of the mesh, which has nothing to do with the surgery to correct this internal prolapse or lack of internal prolapse.
Yes. Your Honor, I think you're going to the issue of causation. What did this have to do with her subsequent adhesions and the mesh? And in that regard, I would point again to our expert affirmation, and he cites to the records of a Dr. Miklos, who finally was able to provide some relief to my client. And at page 32, 47 to 48 of the record. He quotes from Dr. Miklos's records where he said that the mesh was, quote, aggressively adhered to the rectosigmoid area.
But that doctor and none of the other docs, unfortunately, the plaintiff had to have several operations, of course, but none of the doctors in those operations seem to have put anything into the medical record that criticizes what Dr. Key did.
Well,
specifically. Or correct me if I'm wrong. I mean, I didn't see anything like that.
But frankly, Your Honor, I haven't seen cases where doctors come back after the fact and they criticize the doctor. We're not saying that the LAR was performed improperly, but that it should not have been performed at all. That's the issue here. It should not have been because
but the injuries that you're alleging have nothing to do with whether or not that should have been.
Again, I'm sorry, and I don't mean to interrupt you, but I guess I did not complete my answer to the judge.
And those adhesions you're talking about that Dr. Miklos, they're not even close to where that happened.
They are, because Dr. Miklos says that the mesh is aggressively adhered to the rectosigmoid area, and our expert says this is proof positive that this was impacted by the removal of the rectosigmoid colon. That the fact that the mesh was adhered in this area meant that the scarring that occurred as a result of a surgery that is essentially a dirty surgery that contaminated the field is what caused the subsequent adhesions. That my
Was
client
there
was
any
not
evidence that there was any infection or anything by what you're calling a dirty surgery? Did anyone say anything about that?
Our expert did. The adhesions
The adhesions
say
were
that there was
caused by
infection.
dirty surgery?
Well, it's a contaminated field and it
I'm
increases.
asking you whether your expert said that, because
did.
I did not see that.
If I may. Sorry.
Well, while you're looking for that.
Yes.
In order for something to be known as or seen to be a dirty surgery, wouldn't there have had to have been some infection around the time? And there was no infection around the time of the surgery, right?
No, but what our expert explained was that performing that surgery near the mesh increases the inflammatory response of the body to the surgery, and because it's resecting the bowel, and that increased the adhesions.
That doesn't sustain the allegation that it was a dirty surgery.
Well, I'm not saying it in a bad way. It's the nature of the beast, so to speak. This is a bowel resection. You remove 10 inches of her bowel.
I understand that,
Yes.
but for it to be a dirty surgery, and because of where it's at, there would have to have been some infection that followed from this dirty surgery.
I do not believe their expert testified that there had to be an infection that followed from surgery, Your Honor.
Okay.
Thank you, counsel. You have time in rebuttal.
Thank you.
Good afternoon, Your Honors. I'm Judy Shamatsu from Wilson Elser for Dr. Key and the hospital. I want to start with just a very quick housekeeping matter. Dr. Key is a woman.
Right.
There's
we figured it out.
going both ways.
The Alex Key makes it a little. She is a woman, and I would just ask, Your Honors, if the order from this court could use her proper pronouns, which didn't used to be a lightning rod of a thing, but if we could. Going to the issues. I wanted to address this retrosigmoid colon issue, only because what I understand the plaintiff's expert to be saying is not really relevant at all. So if I'm misunderstanding him, that's because he didn't define the term, which is my problem primarily with his affidavit. It is conclusory in that it says that an LAR procedure, and I quote, removes the rectosigmoid colon.
Right, and her resection was simply of the sigmoid colon.
I will move on, Your Honor. Yes, that is my point.
Please.
On the informed consent, I wanted to just make one correction. I had quoted the risks and benefits that Dr. Key discussed with the patient, and I wanted to be clear, my reference is to 2034 of the record, which is not the informed consent form that is her that is her office note, where there is a narrative description of the things that were discussed, and it goes beyond bleeding and infection, and it does discuss that the plaintiff, it specifically says that the patient is aware of the possibility of recurrence, and I wanted to address counsel's point that that is, there's a question of fact about that because of the plaintiff's testimony, and I wanted to point out to this court on record 601, the plaintiff testifies, I don't think she mentioned recurrence, but I don't remember.
May I address, will you address the counsel's statement that it was not good, it was a departure to diagnose the prolapse intraoperatively?
Your Honor, the contemporaneous operative notes of both of the surgeons, this is an open, they're standing there looking at it, and they both see this telescoped situation where it just
Right. I
closes
guess
in on
I guess
itself,
what
right?
I'm saying,
They're
do you
looking
need
at it.
anything more than that? Do you need an expert opinion that that is a way to, that is a proper way to diagnose the problem?
What I see there, Your Honor, is an expert affidavit that does not conform to the facts. These are contemporaneous medical records of surgeons in the room looking at it, saying this is what I'm seeing, and to impeach them this way, to say no, it isn't, basically.
Right. So it's not a question. That's what I guess what I was thinking. It's not a question that's not the plaintiff's expert didn't say that's not a way to diagnose it. The plaintiff's expert is saying it wasn't there.
The plaintiff's expert is saying it wasn't there. I mean, if that creates a question of fact, Your Honor,
right,
there will never be a summary judgment motion in a med
because
mal
I
case.
was confused when counsel said
I
there was
don't-
no expert opinion that
I don't know where that comes from exactly. I think there may be a suggestion that if you had done other testing pre-op, you maybe would have pre-op been able to determine 100% whether you're going to need to address this particular problem. And I think that would resonate in a case where this is the only condition that the patient has. But the reality is this patient was going to have this surgery for the other conditions that Dr. Garley was treating. And he's suspected, and it's not his first rodeo, he's suspected, but he's not in a position to diagnose, that she was also, when he opens her up, he's gonna find this problem. And so the patient herself in her testimony was absolutely clear. She understood that when Dr. Q was gonna be in the room, it was going to be, in case they find this, you know, if A, then B, then they're gonna do the resection, and that was her role, and the patient understood that, everybody understood that, and that's what happened. So if there was other testing they could have done, and I think in this case, it really was just the kind of thing where, look, we open it, we see it, we'll do it.
Counsel was saying that that's an inappropriate way to make the diagnosis. That's what I thought.
I mean, they can see it with their plain eyes. I wanted to raise just one other housekeeping matter. The appeal is from the summary judgment order and the re-arg. In between those two, judgment was entered. And that is, I didn't want to rock the boat too much with respect to what the appeal is from, but I did bring a copy of the judgment, and it's 189, document 189 of the trial docket. And I would just ask this court if it would please to take judicial notice of it and deem the appeal that was taken from the summary judgment order to have been from this judgment, and that way, whatever order results here will accurately reflect the procedural situation that we find ourselves in otherwise. And if the court will allow, I will just hand the judgment to the clerk.
Oh,
so
thank
Your
you,
Honors
counsel.
have
We
it.
can find it if we need it. Thank you.
Thank you, Your Honor.
I will be brief. At page 3242 of the record, our expert at paragraph 17 says, in addition, the January 2, 2015 colonoscopy by Dr. Maria Mirth, done 5 days before Dr. Key's consultation with Ms. Richardson and 20 days before the surgery, was negative for any internal prolapse. It is a disputed issue of fact whether she in fact had a prolapse because the diagnostic imaging taken less than...
Did your expert say that it's inappropriate to look in the person at the time and see it happen? That
No, but
that's not a way to diagnose?
Your Honor, I'd submit to you that the reason that that was not testified to was because their expert never brought it up, and they raised it for the first time in reply. In the reply brief, and I believe it's page 14 or 15, counsel says that it was reasonable to confirm intraoperatively the presence of the internal prolapse, and counsel cites pages 764 and 813-14 of the record. That's Dr. Garley's testimony. I read those pages. I read in the area of those pages. He says nothing of the sort. There is no testimony from a physician or an expert that it was appropriate to confirm the presence of the internal prolapse, which we maintain doesn't exist, until you were in the midst of the surgery. We maintained it was not there.
But it's your burden to say that it wasn't good and accepted. You have to pick what isn't good and accepted.
And we
they
did.
don't have to.
Also, wouldn't Dr.
were the
Garley have
non-movement. We were the
turned to Dr. Key and said, what are you doing here? If this was not the plan. They're both in the operating room. Wouldn't
Well,
Dr.
that's why they should both be defendants. They should both be proceeding to trial.
That's not what I'm saying. I'm saying
Sorry.
that, in other words, if it was not indicated, this was not the plan, that it would be done, that the analysis would be done interoperatively, then what was Dr. Key even doing there in the operating room?
Because Dr. Key was asked, decided with Dr. Garley, because Dr. Key made the decision to simultaneously perform the procedure, that's at page 1027 of the record, to determine whether there was a need to perform the resection.
Right, that was
That's
the
it.
plan.
Right, that was the plan.
That was the plan. But
They both agreed on that.
They did, but it's further our position that the procedure that was performed was far too invasive and was unnecessary. It did not repair any of the conditions that my client went to Dr. Garley for and ultimately Dr. Key.
Thank you. Thank you both. Finally, Canal, Elizabeth Canal versus Structure Tone.
Your Honors, please. Ed Guardaro Jr. for the defendant appellant Structure Tone. First of all, I want to thank the court very much for the opportunity to address it. And secondly, I know I'm on borrowed time, and as one of the justices said earlier in this point, why is this an abuse of discretion? I'll get right to the point. I would submit, Your Honor, that the delay was minor. There was never an intent or willfulness shown, and there's no prejudice. Structure Tone had substantially
It
complied.
was minor, you say, because you did produce a great number of documents that were requested by the other side.
Correct, Your Honor. That is correct. In fact, there were, before this, for 6 years, there was 23 prior disclosures, hundreds and hundreds of documents. And I would submit that, those were targeted and relevant materials for 6 years. And this, 23 discovery responses.
You're not disputing that you didn't comply,
Nope.
right? So you're just saying that striking your answer when essentially the other party has the documents now anyway,
Correct,
is
Your
too
Honor.
severe of a sanction.
Would you be here today if you'd been if a fine had been imposed instead of
No.
striking your answer?
No. Well, no. No, I wouldn't be here. I might be in the case, but I wouldn't be here.
Has everything been turned over?
Everything, it continues. I mean, I know in January, and my learned colleague here will inform you what's been going on post this, discovery continues. I know that in January there were a number of other disclosures made. So it's really just a question of discretion, Your Honors, if I may. Thank you very much.
May it please the court, Jose Aquino for the respondents. The question before the court is whether there was abuse of discretion. We respectfully submit that there's decisions of the court were not capricious, they were not arbitrary, and what we have here is 5,000
Do you have
emails
any showing of willfulness?
Yes, Your Honor.
Which, in what way? Did the counsel say, I don't care what you're doing, I'm not going to respond? Or was the response, I know I'm late, my mother's sick, I had bronchitis, I got to do this, I mean, whatever, right?
Well,
but I'm trying.
If we look at the lower court's decision in...
No, we've read the lower courts. I'm asking you, what do you think was willful about this?
Well, 6 years to produce less than 30 emails.
But what else?
18.
That's not all you asked of them, is it?
Yes.
Only those emails?
This is about the emails. This is not
No,
about
I'm saying, did that party produce other documents?
It produced other documents in
How many?
2020.
How many? Hundreds? Thousands?
I would say hundreds.
Hundreds. So it's not that we're just talking about these few documents, and they had produced everything else.
No, they produced documents in 2020.
They're producing.
Since 2020, we've been trying to get their emails. There's 3 court orders which were ignored, which the court recognized. that
But
they
the
were
courts,
ignored.
Judge Bluth started with the April 18th, 2024 order. Didn't she say that that's the original sin?
But if you look at her decision in the motion to renew, she says, the purportedly new evidence simply supports the court's previous conclusion that the movement repeatedly ignored court orders, plural. And that's on page 17 of the record.
And you think that, I mean, the fact that the emails weren't produced is the proportionate response to that, even though hundreds of other documents were produced, and this litigation is going on for a number of years with a lot of parties, you think the proportionate response to that is strike the...
Yes, Your Honor, because for years we've been going after these emails and they fail to produce them. That the emails are where they have, or where all the evidence is of who was doing what at the project. If they produce contracts, insurance policies, change orders, they don't say anything. The emails are would say who was doing what was wrong, what engineer was
You have
contacted.
emails now?
Your Honor, as of the time the motion was decided, there were 30 emails
No, I'm
produced.
asking you now. Do you have the emails now?
They said they have 5,000 responsive emails. They produced about 1,000 in January.
So the question is, do you know who was doing what, when, where from the
No,
emails?
there's still 4,000 emails missing.
So you don't know who was doing what?
Where?
We have an idea. We have somewhere, but we don't have the emails. We couldn't go.
Well, because they're claiming privilege and other, right?
Excuse me?
They're claiming that they're either not relevant or they're privileged, right? It's not like they're withholding the other 4,000 because they just don't like you.
They produced 30 emails and said we have 30,000 responsive emails. And they never produced those emails until this January. Of those, they only produced 1,000 or so.
Thank you, counsel.
If I may, Your Honors, the emails we're talking about were first asked for in with the deficiency letter of July 11th. There's no doubt about that.
What year?
Of what year?
If you look at 1472, you see
What year?
July 23. The deficiency letter, it was supposed to be a deficiency letter, and those emails first came up for the first time in July 11, 2023. Everything before
When was
that.
the deadline for you to turn over those emails? July
Deadline
2023.
was, responses were due August 31st of 2023.
It's a long time ago.
When did you turn them over?
They were turned over February 21st, 2024.
A year ago?
And why didn't you turn them all over? Counsel says you have some that they can't figure out why you're not turning them over.
So we asked, if I can, if the deficiency letter, when the deficiency letter was sent, that was sent to the client, Structure Tone itself. And they did a search. So over 132,000 emails match those parameters because all of the names in that are.
So of those 132,000, how many were produced?
At that time, there were probably 30, 40.
Oh, but you're saying that they all did, because they just matched the search terms. No one had gone through them to see if they were actually responsive to the request.
Correct.
Once that happened, how many were responsive to the request?
Probably the 1,000 that they got.
Okay, and, all right.
That's basically, what's been going on. And again, I just want to point out that Structure Tone was very carefully deposed over 2 days in the last couple of months. None of this came up, none of it. So shows the relevance of it. Thank you.
Any other questions? Thank you, counsel. Thank you both.